Yes. Hearing we are not taking up. Yes.
This is a fast appeal for
No hearing. Application and order 41, please mention.
Well, this is an urgent matter under order.
in the monthly list of
Order 41 application, please mention with you.
The compelling circumstances. I am on application, my lord. Unless the matter is taken up today, my lord, my matter will be.
It is appearing in the list.
No, my lord.
My lord, to be
This is the problem, my lord. And tomorrow, my lord, there is no division. My lord.
No, nothing can be done. If it is not appearing.
Kindly
Yes.
prepare something, sir. My lord, kindly.
Disposed of matter. Your lordship has directed the substituted appellant to transfer the property in favor of the substituted respondent covered by purchase deed. Now the problem is the matter is now pending before the register bench at City Court, and my lord, your lordship has directed to only execute the deed. Now the respondent side said, who will prepare the deed? And entire responsibility cast upon me that you should prepare the deed and you should pay the registration cost. This is the problem.
Whatever is the law will take its course. We do not do that. Whatever decree you have prayed for, we have granted. So executive court will take that call.
Executing court is saying now the
So we
there is
cannot
no
do anything on
specific
that. Sorry.
direction how.
If you want, you can file a proper application. Yes.
My lord, to be mentioned for correction.
Correction. Yes. Pardon?
hearing.
Hearing we are not taking a call on the list.
Admission. Order 41.
Yes, yes.
Lordship,
Application matter.
Hand over.
Lordship, may I kindly be permitted to mention the serial number 23 of today's list. Lordship, yesterday the matter was called on,
Yes.
and at the time of calling, Lordship found that the paper books are not in the file. And Lordship has inquired to deposit the depositing slip. But Lordship, the unfortunate incident is that the clerk who has filed the paper book has passed away, and the receipt.
No, we directed you to file fresh copies of paper books today.
Lordship, kindly grant me 7 days time.
When the matter is called on, these are not matters to be mentioned in the morning, wasting time. When the matter is called on, mention that.
May I be permitted to mention one application for
Yes, application.
and one for lodging of a final order? Okay. লিখে দিচ্ছি।
Yes, call on. In view of the above observations, FA number 248 of 2008 is disposed of by modifying the impugned judgment and decree dated April 5, 2008, passed by the learned judge, 3rd bench, City Civil Court at Calcutta in title suit number 2369 of 1997, to the extent that the learned trial judge shall, in addition to the reliefs granted by it, quantify the amount of money realized by Swarup Vikas Shet by virtue of the extended succession certificate on the basis of the evidence already on record, and direct it to be paid to the plaintiff's respondents. Till such payment is made, the learned trial judge shall pass appropriate directions for the said amount to be set apart and or for charging the assets of Swarup Vikas to the extent of such sum, if necessary, in the event the money available in this estate of Swarup is not sufficient to meet such payment to the plaintiff respondents. The learned trial judge shall pass appropriate directions of attachment and sale of the assets of Swarup Vikas Shet to the extent necessary for meeting the shortfall amount and direct the said amount to be paid to the plaintiff respondent. Accordingly, the matter is remanded to the learned trial judge for the limited purpose as indicated in the above paragraph, however, without interfering in any manner with the reliefs already granted in the impugned judgment and decree. In view of the inordinate span of time already elapsed in litigation between the parties, the learned trial judge is requested to complete such exercise as expeditiously as the business of the court permits, preferably within 6 months from the date of communication of this order to the trial court. Interim order stand vacated, no order is to cause. We exercise order 41 rule 33. Pending.
Application for order 41 rule 27 wala, that was pending. The reply also opposition reply that was also filed by parties.
The pending application, if any, stands disposal. তাহলে পরে সাইন করে কারেকশন করে দিই, তারপর সাইন করে। Thank you.
I was told that the matter was made returnable on 27th January. Instead, it went down as 27th February. Therefore, it is appearing today as to be.
Oh, আচ্ছা আচ্ছা।
I'm appearing for the ESI
It
corporation.
is an appeal under section 82 of the ESI Act.
Mr. Mujibur, then we'll keep it on 5th of February, the next available date for the revision.
Instead of 5th of February.
No, we already directed to appear on
Yes,
27th.
yes, but in the lower court below, there was a date fixed for 10th of March. An adjournment was
That's
short for on
the-
that day,
The
and that was granted.
circumstances by under
No, I
which
should-
the learned
I should
advocate had been pleased to persuade the court to grant an adjournment.
Yes, what do you say?
Caustic remarks
I
being made
am
against the
not
learned
standing on that.
advocate.
So since, my lord, I should indicate that 10th March is the next date.
That's right,
for
but
the
when
court.
learned and probably
You're
also
for the
for-
appellant.
I am.
Learned senior counsel appearing for the appellant submits that on by the order dated January 20, 2025, comma, although the next returnable date was fixed as January 27, 2025, comma, the said order was erroneously transcribed to fix the returnable date at February 27, 2025. Push up next para. Since January 27, 2025 has already elapsed, comma, we direct the matter to be listed on the next available date, that is on February 5, 2025. Thank you.
Item number 3, my lord, I apologize, I appeared virtually, my lord.
Yes.
My lord, I could not go through the record, my lord. There is a defect that is come from Rojima. My lord, kindly keeps.
Let us check up. You are for the respondent or the appellant?
I am for the appellant, my lord. It is change brief. I have filed Vakalatnama in the department. I have also filed an application for early hearing. There is earlier direction for call for the local record.
Respondent's advocate had undertaken to file Vakalatnama, but has not yet filed. That is the difficulty.
I am for the appellant, my lord. I have filed Vakalatnama, my lord.
Not your problem. And the records
Well,
have
we
also
have-
not arrived. Records have also not arrived. So we'll pass it.
Well, look, well, we have filed an application for preparation of paper book, my lord. There was the earlier direction of before of this honorable court wherein my lord directed to call for the local record. The local records are still not arrived. If my lord so desires, I am ready to pay the special messenger cost also to bring for the local record also.
No, first we want a report from them.
Deeply obliged.
Despite reminders having been duly issued to the trial court, comma, the records have not yet arrived, as it appears from the report of the office dated January 27, 2025. Push up next para. Accordingly, comma, on the prayer of the learned advocate for the appellant, comma, special messenger costs be deposited by the appellant within a week from date. Push up as and when such cost is put in, comma, the records be brought by special messenger. Pushed up next para. We find as well that no Vakalatnama has yet been filed by the respondent. Pushed up next para. Since we find from the previous orders that there had been an appearance recorded on behalf of the respondent, comma, the learned advocate who appeared for the respondent on the last occasion is directed to file Vakalatnama. Push up in the event no Vakalatnama is filed on behalf of the respondent, comma, an administrative notice be sent to the respondent regarding pendency of the appeal. Push up. Yes.
If my lord kindly makes a time frame within which so that or else department will
No.
on the issue.
Put in your special.
As you,
Department
I
has
shall,
done its department has done its duty. It's the trial court which is not sending the record.
I shall deeply obliged.
Thank you. Yes, next. We find from the office report that the name of the appellant in the memorandum of appeal has been inscribed incorrectly. Accordingly, the learned advocate for the appellant is directed to carry out the necessary correction to the cause title of the memorandum of appeal within a fortnight from date. It is also found from the said report that the exhibits of the appellant, that is exhibit numbers 1 to 4 in the trial court record, are certified copies instead of original ones. Next para. No order need be passed to that effect at the present juncture. Next para. Insofar as service of notice of the appeal on the respondent is concerned, the same has not yet returned. Accordingly, the appellant is directed to put in further requisites within a fortnight from date for service of notice of appeal on the respondent afresh.
Your lordship.
Mr. Taraknath Haldar is appearing. He is before courtroom number.
Nothing doing.
Your lordship.
What is the
this
matter?
Sohini Chakraborty is appearing and praying for release the matter from
Shoni
the-
Chakraborty is appearing since when?
since last two orders, 27 June to.
Oh, she appeared?
She appeared.
Yes. We find from the records and as mentioned on behalf of the appellants that that one of the relatives, that a relative of one of us within bracket Bhattacharya J is appearing for the appellants as such, for the sake of propriety, the matter is released from our list on personal ground with liberty to the parties to seek an assignment before a different coordinate bench.
Grateful.
Oi, oh, cousin.
Six lordship.
Husband's
Waiting for the appellant lordship.
What is the matter?
husband's appeal, but I filed an application.
Your application?
Yes, can two kindly takes up note.
Can't hear you. Yes, Mr. Chakraborty.
Can two,
Yes.
Lord, suit filed by the husband. Initially, he filed a suit for restitution of conjugal right.
Yes.
Then he withdrew the suit. Then filed a suit for divorce on the ground of cruelty.
So sorry, please repeat, Mr. Chakraborty. Yes.
Initially, husband filed a suit for restitution of conjugal right, section 9.
Right.
Then he withdrew that suit. He filed a suit for divorce on the ground of cruelty and desertion.
Yes.
I filed a counterclaim for restitution of conjugal rights. The learned trial court was of the view that the cruelty he has failed to prove. He has failed to prove cruelty and dismissed his suit, and my lord did not grant a decree in my counterclaim also.
Did not grant.
No, he filed an appeal challenging the dismissal of the suit. Now, my lord, in the appeal, I have filed an application for alimony pendent related.
So you have not challenged that
No, I
restitution?
have not challenged as of now. Now, my lord, two information to your lordships, my lord. They have filed paper books. If your lordships have the paper book, or I will show, my lord. In the earlier suit for restitution of conjugal right, the court granted an alimony of 8,000 per month. He paid that for some time, then withdrew the suit. Then he filed the present suit in the trial court, where, my lord, if my lord takes up can 2, the court, my lord, at page 16 passed an order for payment of 15,000 per month, including 5,000 paid by 125 court. My lord, is at page 20 of the application. Kindly come to the ordering portion.
Seen it.
Now, this he has paid
up
till, my lord, I tell you, lordships, my lord, the date. This he has paid, my lord, up till the dismissal of the suit. Since then, nothing has been paid according to this amount, and he has also stopped paying under the 125 order also. Till today, on the same amount, the due is 3,80,000. Lord, he earns 1,50,000 as on.
No, that was an interim order. How can that due be taken into consideration here?
I am not saying that. What I'm saying that on that rate also, he has not paid at all. It is his
You
due.
did not apply for alimony
I
for
did not
2 years of pendency of the appeal.
not apply,
You
my lord.
cannot claim before the date of filing of this
I am not
application.
claiming. I am saying that if
There cannot be any dues. Dues in 125, you have to take appropriate steps there.
now today, I say that he earns 1,50,000.
That is
per
your
month.
affidavit of asset.
Lord, I have not filed any
You
affidavit
have
of
to
asset.
now.
I'm not kindly direct both the parties to file, not I'll file. I don't earn anything. I'll file one page affidavit. Let him also disclose his
And your
income,
assets
Lord.
also, other assets also.
Yes, sir,
If
let
you
him also
have it.
disclose his income, Lord.
We'll give you how much time for filing that affidavit of asset?
But 2 weeks would be.
2 weeks, then your application gets delayed.
1 week I'll file. They will also take some time if they. I
Very well.
can file. it
We'll
within a
give you 3 weeks time for filing opposition and your affidavit of asset.
Yes.
Well.
that-
For mediation also, Lordship. In fact,
Mediation failed.
mediation failed in mediation, Lordship. Our client,
Please use the microphone, ma'am. Yes.
Lordship, in the process of mediation, Lordship,
Yes.
we made all endeavors to settle the matter with one-time alimony, Lordship, in the presence of the honorable
If
mediator.
it failed, it failed. We cannot
It,
help
it
you.
failed, Lordship.
Lord,
Yes,
may I
Lordship.
just draw your
And
lordship?
Lordship, the parties are staying separately for more than 11.5 years,
That
Lordship.
will decide in the appeal itself.
Yes, Lordship.
So if you are agreeable to divorce, then you are seeking divorce.
Yes,
May
Lordship.
I just draw your lordship's attention to
Yes,
only
Mr.
one
Bhatt.
thing? Page 19 of the application.
Can there be an agreement even before the court for alimony? Because it all boils down to alimony now.
I will talk to the client, Lord. It is also like a legal aid matter for me. I will talk to her. And Lord,
Very well.
I'll
If
try
you
to
can
impose
settle
my
on the alimony, then because you are also not pressing your restitution now.
Absolutely.
So we can let you go apart.
Not only one thing, if my lord grants me something to survive, although I don't have
No,
the
no,
face
you have
to
filed
ask
the
because
application
2
after
weeks.
2 years now.
No problem.
The present application has been filed by the appellant, by the respondent wife for alimony pendenti lite. Whose sub next para, although learned counsel for the respondent stroke petitioner seeks an ad hoc payment before the application is decided, comma, we find that the application has been filed about 2 years after the institution of the appeal, and as such do not find any pressing urgency to grant such order at the present juncture. Whose sub next para. We also find that the application for alimony is not accompanied by any affidavit of asset of the respondent stroke petitioner wife. So accordingly, the petitioner wife is directed to file her affidavit of asset within a week from date. Full stop. A composite affidavit in opposition to the application and the affidavit of asset of the wife, along with the independent affidavit of asset of the appellant husband, shall be filed within 3 weeks thereafter. Full stop. Reply, if any, shall be filed within a week subsequently. Full stop. Liberty to the parties to mention the application for inclusion in the list after the above timeline is over.
Grateful.
প্রথম লাইনে একটা অ্যাড করে দেবে, affidavit of service filed to be kept on record.
I appear for the respondent.
With the risk of being severely admonished by your lordship,
Yes.
my lord, may I pray for an extreme indulgence, my lord, praying for the second extension to file the affidavits in reply. There are 4 affidavits in opposition to which we had to file the reply. But it
What
was
is the reason for such delay?
my lord, they are staying outside Calcutta. I am told that they have already posted, but we have not received the.
Aliganj Park.
No, but
Oh, you are
Constituted Attorney
New Delhi.
stays in Delhi.
What
They
do you
have-
say to that?
But I will not
I,
come in the.
I had informed them, my lord, that I would be seeking an
Information
extension.
does not mean consent.
No, but I had informed.
So how much time?
But a week's time. Well, I am told it has already been posted. We will be receiving it. But
You are
today or
enjoying any interim order?
No.
Then in any event, you are not taking undue advantage.
No.
So we'll give you 1 week or a fortnight.
1 week. It has already been posted. We are yet to receive that.
My lord, I'll just seek one indulgence,
Yes.
my lord. If the matter is just returnable after 11th of February.
After
Any day
11th of
after
February,
11th.
definitely. On the prayer of learned counsel for the appellant, comma, the time for filing reply to the application is extended till February 7, 2025. Full stop. The matter shall next be listed. The application shall be listed for hearing on February 12, 2025.
I'm sorry.
I am the appellant petitioner, my lord.
So for the respondents.
Initially, the entry
1 and 2 are the only respondents, or
only respondent. And the 1 and 2 dispensed with the state
the
respondent.
others are well.
Others.
Yes. What is the matter about?
But initially the interim order not to disturb my physical position, my past. And thereafter,
Please use the microphone. We can't hear you.
initially, my lord, the entry order was passed here, not to disturb my physical position, and thereafter the direction to file affidavits, exchange of affidavits, affidavit file, opposition and reply or file, my lord.
What is this appeal
the
arising
matter?
out of?
Yes, arising out of, my lord, the
This is can 2 which you are hearing.
yes, can too. My lord, the respondents filed a suit against me,
Yes.
seeking your appellant is a trespasser of the property.
Eviction.
Property. But however, not to seek any recovery of possession.
They did not ask for recovery.
No.
What was the really sought in the suit?
A trespasser declaration. The defendant is a trespasser of the property, and he has no right to connect electricity meter connection.
That
Only.
was the suit.
That was the suit. And
Why
my
shouldn't
lord-
it be barred by section 34?
Section 34. And my lord-
They,
Suit has not been praised further. My lord, suit has been withdrawn. Thereafter, the learned court below proceeded on the basis of the counterclaim, and counterclaim has been rejected by the learned court below. Against that, my learned friend is before
Yes.
your lordships before appeal.
what was the counterclaim for?
Yes, sir. I filed
Claiming
counter claiming title. No.
No,
No
before
title.
you reach, he has reached already the final. Yes. What was the counterclaim for?
Now, in the counterclaim, they played for title. Now, lordship, title, the claim of title is incorrect in view of the fact that the ordinal property, the property.
On the merits, we'll hear him first.
Yes.
On the merits, we'll hear him. Yes. Yes.
I'm not paid for title, my lord. Not six title. I am only right to enjoy my position.
In what capacity?
1/4 share. I am the admittedly I am
1/4 share is not title.
I am title 1/4 share of the course. I
You
am
say I do not pay for title, but you are seeking declaration of your 1/4 share. Which
title
title?
already been declared, my lord, earlier in a suit, my lord, 1985.
They were a party there.
Yes, they are a party. And admittedly, the respondent is a 1/4 share of the property, and I am 1/4 share of the property.
Why was your counterclaim dismissed?
A counterclaim dismissed by the observation by the learned court below. A co-sharer without any partition could not be seek.
Could not?
No, not to seek. Not
Without claiming partition, you
claim-
cannot seek any share.
seek any the enjoyment of specific portion of his physical position. Only the case.
What injunction did we pass? Let us see.
Biological. The order dated 20th November 2024. The interim order was granted. Madam.
Yes, Mr. They, what do you say?
In this regard, lordship, I will very humbly submit to your lordship to take up only 3 paragraphs in my affidavit in opposition. My first point is, in a previous suit, in their deposition, they have clearly said that they doesn't stay over here. They stay in a different address. The address was given. Now,
Where is that? Where is that?
Yes, if your lordship kindly comes to page 15 of my affidavit in opposition. I have been residing at 44 Dhiren Dhar Sharoni, 7,12,000 since 1981-82.
All right.
Now, lordship, I have clearly stated in paragraph number.
No, they may have be staying there, but they may also have possession in respect of this property.
No, I tell your lordship.
Staying physically, they may be staying elsewhere, but they have possession of this property.
So far, the possession of the property is concerned, I've given a picture of it in my at page para 15.
Page?
Para 15, lordship, of my affidavit, which is at page 5.
Yes.
I submit that the suit premises is a G+1 storied building having an area of 2 kata 4 chitaks. On the ground floor, there are 4 rooms. One room is occupied by a tenant, namely Tarak Mondal. One room is used as office by Rakesh Kumar Jaiswal, the respondent number 1 herein. One room in the possession of Rajesh Jaiswal, and another room which was in the possession of the elder sister Shubha Bhagat, but is now in the possession of Rajesh Jaiswal, who entered forcefully in the room. On the first floor, there are 3 rooms. 2 rooms under the occupation and possession of Rakesh Kumar Jaiswal, the respondent number 1 herein, and another room is in possession of Rajesh Jaiswal. These are the rooms and these are the accommodations which this house can provide.
What do they say in reply to this paragraph? Let us see.
They have only denied it. They have claimed possession and denied it. 15. only saying that this appellant further, the last three lines, this
Hmm.
appellant further states that the appellant petitioner is occupying and possessing all that 2 rooms in the first floor exclusively, along with common bathroom, common space, courtyard in the
What
ground.
proof of possession have you annexed?
My lord,
Have you annexed any proof of possession?
yes, my lord.
What document?
My lord, the one, my lord, the
Show us
CS,
from the injunction application. What is your proof of possession? Your injunction application or your reply must disclose some document to show that you are in possession.
my lord, kindly, the page number, the High Court order, injunction granted, High Court order, page 73. Page 73, relevant page 74, second paragraph. Although the, my lord, C6, I am the trespassers.
No, that is different.
Yes. And my lord, the again,
Page 74 is the relevant page.
yes, 74 is a relevant page, second paragraph, my lord.
And also they had filed a suit for your eviction. Not eviction, for declaration that you are a trespasser.
Was a
So
trespasser.
that is probably an admission that you are in possession.
Yes.
Nothing
And
to
my lord, the in the suit, he seeks also, I am not to right to connect the electricity meter also. Meter was already connected.
so that is an admission of your
Admission.
and they did not press that suit ultimately.
They not withdrawn the suit.
Yes.
And also the my lord, the 74 High Court order observation, kindly see second paragraph, page 74.
Yes.
In the case before us, admittedly the appellant has 1/4 share. The submission that he is not residing at the suit premises does not by any strength of imagination take away in his ownership in the property. Ownership is a right which includes all other minor rights, including the right of renovation of the premises. The submission advanced by Mr. Chatterjee, we are sorry to say, is altogether devoid any.
Yes, yes, we have heard you. Yes, yes, Mr. Dev, what do you say?
This was an injunction application
I
connected to.
renovated the.
You had filed a suit for
I have filed a suit for.
and you have not pressed, but there is no change of circumstance. We don't find any changes. So we'll maintain the news. The present appeal arises out of the dismissal of a counterclaim by the appellant, comma, seeking the relief of declaration of the appellant's 1/4 share in the suit property and consequential reliefs. Full stop, next para, the counterclaim arose out of a suit filed by the respondents 1 and 2 for declaration that the appellant is a trespasser in respect of the property and also in respect of the appellant not being entitled to enjoy electricity connection at the suit premises. Full stop. Learned counsel for the respondent numbers 1 and 2 submits, comma, by placing reliance on an extract from the evidence adduced by the appellant in connection with in a different suit, Mr. Dev, in a previous suit, comma, that it was admitted by the appellant that he was residing at a different address than the suit premises, that is at 44 Dhiren Dhar Saroni, comma, Kolkata 7,12,000 since 1981-82. Full stop. Next para, the respondent numbers 1 and 2 also place reliance on the averments in their affidavit in opposition, comma, in particular paragraph 15 thereof, where the said respondents have delineated the alleged possession in respect of the 2 floors of the property, comma, from which it is seen that the appellant does not find place in the array of occupants of the property. Which of next para, however, comma, in reply, comma, learned counsel for the petitioner submits that by dint of filing a suit for declaration that the appellant is a trespasser, comma, as well as seeking reliefs to restrain the appellant from enjoying electricity, comma, the respondent numbers 1 and 2 automatically admitted the possession of the appellant. Full stop. Next para. Upon hearing learned counsel, we find that even if the appellant had adduced evidence in a previous suit stating that he is residing elsewhere than the suit property, such other residents need not be necessarily mutually exclusive with the claim of possession of the suit property as well, since uh, such residence of the appellant in a different property may very well be over and above the suit property. Full stop. Next para. That apart, although the present suit has not been pressed by the respondent numbers 1 and 2 subsequently, fact remains that the suit was filed by the respondent numbers 1 and 2 seeking a declaration that the appellant is a trespasser in respect of the suit property and is not entitled to electricity connection, which automatically gives rise to the presumption that the appellant is in occupation of the property. Full stop. Despite the suit having not been pressed subsequently, there is nothing on record to show any change of circumstances thereafter. Full stop. Thus, as per the last admitted position by the respondent numbers 1 and 2 themselves, the appellant is in occupation of a portion of the present property. Full stop. Accordingly, we do not find any reason to deviate from the ad interim injunction granted earlier. Pushed up. Hence, Can 2 of 2024 is allowed on contest, thereby restraining the respondent numbers 1 and 2 from disturbing the peaceful position and enjoyment, peaceful physical position and enjoyment of the portion of the suit property which is in occupation of the appellant stroke petitioner till disposal of the appeal. Push up. Next para. In view of appearance of the respondent numbers 1 and 2 through the learned advocates, service of notice of appeal on the said respondents is dispensed with. Full stop. 3 and 4 contested in the court below.
No, my lord. Dispensed with already, my lord. The
No, dispensed with regarding the application. Regarding the appeal, they did not contest in this suit.
did not contest.
Since it is submitted by learned counsel for the appellant that the pro forma respondents.
My lord, WS also filed there. Thereafter, not proceed with the CSC. Respondent number 3 and 4. Written statement filed.
Counterclaim, you have asked for reliefs against them?
No.
No.
No relief against them.
Since it is submitted by learned counsel for the appellant that no relief has been claimed against the pro forma respondents. Sorry, we have to stand.
Fine.
Martyrs Day.
But only one thing, my lord, may I just indicate to your lordship? There was another appeal which is pending before this Honorable High Court.
No, let us finish this. We're in the midst of an order. Yes. Since it is submitted by learned counsel for the appellant that no relief has been claimed in the counterclaim against the pro forma respondents, comma, service of notice of appeal on the pro forma respondent numbers 3 and 4 is dispensed with. Full stop. The records shall be called for by special. The trial court record shall be called for by special messenger at the cost of the appellant, comma, to be deposited within a week from date. Full stop. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant, who shall liberty to the parties to mention the appeal for hearing when the same is ready. Yes, you are saying something?
I was indicating page 109 of the main application for injunction, wherein in an appeal from the probate proceeding, this Honorable High Court has already passed an order for status quo amongst the parties.
Whatever, we pass an independent. Yes, next. Thanks. Thanks. Thank you.
Now, your lordship, I'm for the appellant. This is my affidavit, sir.
Yes.
Your lordship, I'm come up before your lordship challenging the final degree proceeding in a suit for partition.
Yes.
And I filed this application for injunction restraining the opposite party from changing the nature character and from transferring, alienating, and on encumbering or creating any third party interest. Your lordship, during the final degree proceeding, there was an order of status quo. It is at page number 38, your lordship. I challenged, also filed my written objection against the partition commissioner report. That has been rejected and the final degree proceeding has been allowed.
So now you want an injunction regarding?
Restraining the opposite party from changing the nature character of the land and from transferring, alienating.
And peaceful possession.
Yes.
Possession was found by the trial court. Let us see page 35. You said page 35?
38, your lordship.
38.
38.
38 of the application.
38 is the order of status quo.
Achha, yes. Only nature and character. Regarding possession, there is nothing. What is your proof of possession?
Possession, your lordship. At present, the part I actually have challenged the possession allotted by the partition commission.
No, that has not been. The decree has been executed.
No, it has not been executed.
You are not seeking any execution of the decree. Any stay of execution of the decree will be executed.
No, your lordship, it has not. Execution has not been filed till yet.
We are not sure of your position. How do you show us something to show that you are in position? Nature character status quo, because nature character was granted by the trial court, we can give that. And transfer alienation also we can consider. But position, there is nothing. Have you avoided in your application that you are in position?
Your lordship, as this is a joint property, your lordship.
Joint property means, yes, notionally, every kosher in occupation of everybody. But physical possession, injunction is granted if there is physical possession on. Yes. Even otherwise, if you don't have physical possession, even if you don't grant injunction, their possession will be your possession. But we cannot grant any injunction regarding possession then.
Status quo, your lordship.
No, status quo means nothing. We will grant injunction outright, restraining them from changing nature character and transferring it. But why haven't you passed a stay order of the... Your senior must answer that to you in his chamber. The present affidavit of service filed today be kept on record, which indicates that proper service has been effected on the respondent. Full stop. The appeal arises out of a final decree of partition. Full stop. Learned counsel for the appellant points out that during pendency of the suit, comma, the learned trial judge, comma, by an order dated August 27, June 26, 2019, comma, had passed an order of status quo as regards nature and character of the suit property till disposal of the final degree application. Puts up next para. Although the appellant stroke petitioner has sought injunction in respect of the possession of the appellant as well, comma, we do not find anything on record to indicate that the appellant is in actual physical possession of any portion of the property, although it is trite law that the possession by any of the co-sharers is deemed possession of the other co-sharers as well. Full stop. However, comma, no injunction order can be passed unless actual physical possession is shown. Full stop. Be that as it may, comma, with unless the other prayers for injunction as sought in the present application are granted, comma, the appeal might be rendered infructuous. Full stop. Accordingly, can 1 of 2024 is allowed, comma, thereby restraining the respondent and or his men and agents from selling, transferring, alienating and or encumbering the suit property in favor of any third party in any manner whatsoever, and stroke or from changing the nature and character of the suit property till disposal of the appeal. Full stop. The appellant shall put in due requisites for service of notice on the respondent. Full stop. The trial court records shall be brought by special messenger at the cost of the appellant, also to be deposited within a week from date. Full stop. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing.
Very well. Your Lordship, the appellants were allotted portion in the decree, Your Lordship, final decree proceeding. We can find that from the
Allotted
judge.
portion, but you are challenging that decree.
Yes.
So you cannot rely on, you cannot blow hot and cold in the same breath. You are saying you are already in possession.
Already I'm position on the part
Then
that
you
has been
concede to the final decree. Don't withdraw your appeal.
No, I'm not.
Then by the final decree, possession has been allotted to you.
I'm challenging that.
But you are challenging that.
That
So you cannot rely on that at the same time saying that I should be in possession.
But the allotment which has been given.
If the allotment is given to you, if the decree is executed only, then you will get that possession. How do you get possession unless the final decree which you are challenging is executed? Next matter.
I'm for the appellant, my lord, praying for some time as there is.
Oh, move the matter. Application is no time. What is the matter about? This is appearing for the first time or you have served copy on the other? Order for tune. Acha. What is the defect? Have you checked up?
Yes, my lord.
What
I
is the
checked.
defect?
In the degree of the trial court, the
Please
first,
come a bit closer to the. Yes.
the degree of the trial court, the first page is missing.
So then you file a proper certified copy of the
Yeah,
trial.
I will. I mean, praying
Why
for
didn't you
some
take
time.
steps till now? We find from the report of the additional stamp reporter dated October 31, 2019 that the appeal is defective inasmuch as the first page of the certified copy of the trial court's decree is missing. Full stop. Next para. Unless such first page is, unless a complete certified copy of the trial court's decree is filed, comma, the particulars of valuation as well as parties cannot be verified. Full stop. It is unfortunate that although the appeal was filed in the year 2019, comma, the appellant did not find time till date to cure such defect. Full stop. In any event, comma, on the prayer of the learned advocate for the appellant, comma, we direct the appellant to file a proper and complete certified copy of the trial court's decree within 4 weeks from date. Full stop. Next para. Upon such, now the office shall file a further report in that regard. Full stop. The matter shall be placed in the list under the same heading in the monthly list of March 2025 for passing further orders.
Item number 11, Lordship. In this, I'm for the appellant, Lordship. In this morning, Lordship, we got instruction from the client, Lordship, that respondent number 4 has expired, Lordship.
So what about that?
Lordship.
You have to take steps.
Yes, Lordship.
Learned counsel for the appellant submits that the respondent number 4 has died during pendency of the appeal. Full stop. Accordingly, on the prayer of the appellant, comma, leave is granted to the appellant to take appropriate steps for substitution of the heirs and legal representatives of the said deceased respondent. So, sub, let the matter go out of the list for the present, with liberty to the parties to mention the substitution application as and when filed. What is the defect?
The trial court's judgment and decree has not been filed at the time of filing, which is ready with me.
Ready?
Kindly allow me, I'll file it by tomorrow and let the matter come up.
Very well. Trial court judgment and decree, nothing was filed.
Photocopy was filed or
Achha. Learned counsel for the appellant submits that the appellant is now in possession of the certified copy of the judgment and decree of the trial court, comma, due to non-filing of which the appeal has been marked defective. Push up accordingly, comma, the appellant is directed to file the said certified copy in the department by tomorrow, that is January 31, 2025. Pushed up, the office shall file a further report in that regard and place the matter before this court under the same heading on February 17, 2025. ফাইলটা পাঠিয়ে দেবেন, অফিসকে বলে দেবেন, উনি ফাইল করলে একটা রিপোর্ট দিয়ে 17 ফেব্রুয়ারি আবার অর্ডার ফর টিউনিটি।
Since there is a execution pending before the trial court, can the date fix report?
Office will take some time to give a report. That's the difficulty, and we have this 3rd and 4th February holiday. That's why we have kept it only. So where we will put it on 10th. তাহলে ওটা রিটার্নেবল ডেটটা ফেব্রুয়ারি 17 না করে ফেব্রুয়ারি 10th করে এটা ইমিডিয়েটলি অফিসে পাঠিয়ে দেবেন আর বলে দেবেন, হ্যাঁ, 10th February.
The plaintiff's appeal from an order of dismissal of Order 39 Rule 1 and 2 application on contest. The suit is for injunction. The plaintiffs had purchased a property under court auction in winding up sale. After purchase of the property, the plaintiffs wanted to guard put up a boundary wall outside its factory precincts, because there was, for two reasons. There was a river which is flowing on the other side where there is erosion, so the entire stacking of the jute had to be shifted to this side. But there are several encroachers outside the area who are creating the disturbance. So my suit is for injunction, restraining any of the defendants from disturbing my construction of the boundary wall. From an ad interim,
Defendants are the who are they?
They claim to be occupiers of different portions
Of your property.
of a portion of my property. The suit property is a portion.
So then what you are seeking is virtually eviction in the garb of.
No, that is why I was saying.
That is why it was dismissed.
No, that was not.
Achha.
But by the deed which
You also admit that they are in occupation in some portion.
they are in occupation in some portion.
So you want to put up a boundary wall with them inside?
No, with them outside. They are outside. They are outside. I am wanting to put a boundary wall in a vacant land which adjoins my factory land. May I just indicate the facts?
What about the respondents? They were appearing on the
They were appearing. If your lordship kindly sees the last order of 15th of January.
Yes. Mr. Parthopratim Rai, we know has gone to acquire some good blessings in the Mahakumbh. Yes. Mr. Parthopratim Rai. We don't know whether this litigation was the reason for that. He has gone. We know that. But Mr. Rajdeep Bhattacharya appeared online today.
Yes.
His last order, what happened?
Last
LR
order
record of
kindly says
right.
there was a direction
Yes.
on them to produce the LR record of rights, which was shown to the court, my lord, in course of hearing of the application, but not annexed. And on that basis, the order was passed dismissing my application. We had asked for a copy of these LR records, which they were showing. They have not given. There was a specific direction of the honorable court.
But your injunction is restraining them from preventing you from building up a boundary
The
wall.
boundary wall.
So that's in a way a positive order. I mean,
Yes, but
not a negative order.
I understand. but my lord, it's in the nature of a mandatory order and the interim
In a
stage.
sense, yes.
Yes,
So
absolutely.
therefore, without them, I mean,
No, I am not pressing for that. Just in a nutshell, in a minute. But I
affidavits were directed in this
No.
injunction application.
no, because affidavits were completed before the trial court.
Achha.
On contest, this was dismissed. So from the final order, the problem is I am facing the threat of it being encroached.
So let us see the impute order that LR records have been relied on.
Yes, and on that basis, my lord,
Say no copy was given to you.
No.
You have taken that as a ground in your
Yes.
memo. So we'll admit the appeal, but direct you to serve copy of the injunction application on them.
That we have. They were appearing.
Without the appeal being admitted.
But we had already served because my lord, they were on caveat. So we had served them.
So we'll admit the appeal and then
Yes, my lord,
await there whenever he comes back.
but kindly keeps a short date, my lord.
Yes, absolutely.
At least for the
We'll request you to
that order.
you will request you to give a notice to them that if they
That
don't
I shall,
appear,
but at least to comply with the order, kindly give them so that we can see what they had relied upon. And thereafter, whenever Mr. Rai comes back, I'm not saying that in his
no,
absence, my
Mr.
lord, it should be done.
Gupta,
But there was an order already.
There's some difficulty. If the LR record of right are produced, even can we rely on that without those being annexed to some affidavit?
Exactly. So they did not annex to that affidavit. They just handed it over in court, and on that
No,
basis.
in this court, there is no affidavit has been directed.
No, I'm not
You have
saying.
to have an
I'm
opportunity
not
to do
saying that. My lord, I'm saying that there was a direction
Anyway, very well. I get your point.
on them to produce that. Well, let that be
Well,
produced.
we find from the records that on January 15, 2025, a coordinate bench had directed the respondents to produce the extracts of the LR records of rights, on the basis of which the temporary injunction application of the appellant was dismissed in the trial court. Full stop. The brief facts are that the appellant filed a suit for permanent injunction restraining the respondents from preventing the appellant from building a boundary wall around the appellant's property. Full stop. The appellant alleges that the respondents are rank outsiders who seek to encroach upon the property, whereas the respondents apparently took a stand that they are in occupation of portions of the suit property. Full stop. Next para, learned counsel for the appellant submits that when that the respondents had, all on a sudden, produced extracts of the LR records purportedly showing their possession before the trial court at the time of hearing of the injunction application without any copy thereof being given to the appellant and or being annexed to the affidavit in opposition written objection filed by the respondents in the court below. Full stop. As such, the appellant did not have any opportunity to deal with the said extracts and or controvert those. Full stop. Next para, we find that in view of the circumstances as indicated above, a sufficient prima facie case has been made out by the appellant. Full stop. Since such issues as well as the other questions raised in the memorandum of appeal are required to be heard on merits, we hereby admit the appeal. Full stop. Next para. The respondents are not represented today at the time of call. Full stop. Accordingly, we direct the respondents to comply with the order dated January 15, 2025 and positively produce the extracts of the LR records of rights on which they banked upon to obtain a dismissal order of the appellant's injunction application in the court below on the returnable date. Full stop. The matter shall next be listed on February 6, 2025 under the heading application. Full stop. Next para, the learned advocate on record for the appellant is requested to give a notice intimating the gist of this order and or a server copy of this order to the learned advocate on record for the respondents to ensure the respondents present with the extracts of the said LR records on the returnable date. Please file a receipt of that on the next day if they don't appear.
One thing, my lord, possibly, my lord, your lordship had indicated as my submission
Yes.
that they had produced the record of rights to show their possession, but
yes,
that was not there. Somebody else was there. That was their content, third party, some Hanuman cotton mill. So only that portion, if it not their possession, but
একটা জায়গায় বলেছি produce the LR records at the time of hearing. Then how was that a reason for your injunction being dismissed?
They say that I do not have possession, somebody else's name is recorded. That is what they had contended, which is reflected in the impugned order.
একটু মেঘনা তো
They don't say that they are in
একটু কি কোথায় বলিস এখন তখন বাদে পার করা মুশকিল
in the
একটা জায়গায়
initial
বলছি।
portion, my lord.
না না অ্যাকর্ডিংলি ডাইরেক্ট না একদম শুরু থেকে শুরুটা পড়ুন একদম প্রথম লাইন থেকে পড়ুন আচ্ছা তার পরের সেন্টেন্সটা বা পরের প্যারাগ্রাফটা পড়ুন হ্যাঁ তারপর produced at the time of final respondents had produced respondents had extract showing their position টা কেটে দিন showing their position টা না করে showing the position of third parties other than the appellant.
Yes, that's it.
Third parties other than the appellant.
I'm so grateful.
Thank you.
I'm so grateful.
Thank you. আগেরটা কিন্তু পরের দিন অ্যাপ্লিকেশনে থাকবে বলে দিয়েছি খেয়াল
My lord, regarding item number 14, my lord, Mrs. Rishoprita Ghosh is appearing for the appellant, my lord. Yesterday, my lord, while returning home, he fall down from rickshaw, my lord. There is a hairline fracture on his legs, my doctor advised 3 weeks adjournment.
2 weeks.
3 weeks, doctor told for 3 weeks rest, my lord, bed rest. And in the adjourn for 4 weeks, my lord.
So when should he keep it?
My lord, any day, my lord, after 4 weeks, my lord. Doctor advised for 3 weeks, my lord, bed rest.
An adjournment is sought on the ground that the learned advocate for the appellant is indisposed. Full stop. Next para. Accordingly, let the matter stand adjourned and be listed in the monthly list of March 2025 under the same heading.
My lord, I appear for the respect number 1. Yesterday, your lordship was pleased to condone the 45 days delay, and there was a direction to serve the copy of the application for stay and the memo of appeal subject to correction. Because today morning only I have received the application for stay. I am praying for.
My learned friends junior, he got vanished. We couldn't see him. I had the copy. I just handed over to my learned friend. Yesterday I intended to hand over
Appeal
the
order
copy.
41 hearing, you don't have a right of hearing, but immediately thereafter you will take up the stay. So no use taking up today. This is against an injunction order.
Injunction order, your lordship. It's a suit for declaration and permanent injunction. In alternative prayer was partition. It's an admitted fact that the parties to the suit, they all are family members. They are jointly, it's not jointly, it's a 13 decimals of land. By demarcations, they are in possession of their respective property since 1950. Now, all on a sudden, my lord, the plaintiff, he alleged that he's a co-sharer. After the death of his father, he owned a certain portions of the property. Now, the appellant before your lordship, they are also in possession, and there are constructions over the same. Now they are making certain further constructions work, and that was this.
You are making certain further constructions.
Yes, lordship. My lord, kindly, if your lordship.
What is the impugned order?
That page 38 probably subject to correction.
What is the impugned order?
To maintain the status.
Please, don't have a right of hearing. Please take your seat. Yes. Yes, Mr. Haq.
Yes, lordship. My lord, at page 41.
Page 41, no. Show us from the memo. Order dated?
This is order dated
13th March.
20th April 2024. Initially, your lordship, the plaintiff moved an application for injunction. That is on 13th of March 2024.
No, 20th February is a police help order.
No. 20th April?
20th April order number 9 is a police help order.
10th of April 2024.
Say that, you said 20th.
Initially, an application was moved.
What is the impugned order in the memo? You can't say. We are asking you a simple question. What is the order impugned in the memo? Yes, 10th of April is the order,
yes,
not
lordship.
20th of April. You are taking
Yes,
us to those orders. Yes, let us see the 10th April order. So they filed a suit for declaration, alternatively partition and permanent injunction, right?
Yes, Your Lordship. So
They
initially,
admit you are a co-sharer.
yes.
What injunction was granted? Let us see. Let us see the impugned order. Status quo, how are you agreed? What injunction was sought by them? What sort of temporary injunction was sought by them? Regarding construction.
Yes, Your Lordship.
Yes, status quo is where if you make constructions, the nature and character will be changed. And you can
Yes.
claim a special equity. So rightly injunction granted. Why should you admit the appeal at all?
My lord, my construction,
Yes.
my lord, kindly take my written statement, wherein I had stated that I am not making anything, Your Lordship, that
If you're not making
I'm not-
anything, then
I'm
the
not
status quo does not affect you.
I'm not claiming any right over it. Even if I make the
not claiming-
constructions work.
No. Making construction may create irreversible rights. Even if you say that you won't claim any right, suppose you are in occupation of the better portion, you may make a construction on the better portion of the property. It would be a very difficult task for the court to then direct it to be demolished and all. That would create irreversible rights also. No. We don't find any illegality in the status code. Sorry.
Lord,
We'll dismiss
most of the constructions being made, only the roof portion is there. The entire construction is being made, Your Lordship.
You are residing somewhere, must be.
There only. It's a part of it. It's a part of my land.
No. If you are residing there, how can you make a construction there? If you make
Side of it.
So therefore, you are residing somewhere else.
Yes.
In the property, same property, maybe you
The
have a residence.
building materials are there, all are lying out there. And see how this order was passed, Your Lordship. Kindly look into the earlier order, 13/3/2024.
We'll admit the appeal. We'll direct you to serve copies of the memo and all.
We served, Your Lordship.
We have already served the injunction also. We'll direct them to file. We are not granting any stay at this stage. That would allow the appeal.
Yes, Your
You
Lordship.
file your opposition, we'll give you some time. Because the question which is to be decided is whether after making so much construction, I mean, if it was a new construction, they would have understood. If they have already made the construction substantially, whether you can pass an injunction, not an injunction, they would complete the construction but won't claim any equity on that. That will be the scope of this appeal. The appellants, the present appeal is preferred against an order whereby ad interim status quo or injunction was disposed of. Whereby an ad interim order of status quo was passed, restraining both parties from changing the nature and character of the suit property. Of learned counsel for the appellant submits that the construction on the property has substantially been completed by the appellants and only the completion of the roof is left. Next para, if at this stage, comma, an injunction is granted, comma, the already completed construction would the already completed the building materials lying in the property would deteriorate and the substantial rights of the appellant as a co-sharer would be affected. It is further submitted that the appellants are agreeable to undertake that they shall not claim any special equity if they are permitted to complete the construction. Next para, we find from the grounds taken in the memorandum of appeal and as pleaded, comma, that sufficient arguable case has been made out for hearing the appeal on merits. Accordingly, FMAT 291 of 2024 is admitted. Since copies of the memorandum of appeal and the injunction application have already been served on the respondents. You are for all the respondents.
No, my lord. Respondent number 1.
Respondent number 1, comma, the appellant shall serve copies of the memorandum of appeal and the injunction on the other respondents, that is respondent numbers 2 to 6, and file an affidavit of service on the next returnable date. Next para, such service shall be deemed to be service of notice of the appeal as well. In view of the short conspectus of the appeal, comma, the trial court records need not be called for. Let it be understood that the appeal as well as the application shall be taken up for final decision on the next returnable date. Full stop. There's a delay. No, delay we have
Delay was
allowed.
condoned, your lordship.
On the last occasion, they allowed.
Delay was condoned.
Last
Yes,
delay. Okay, time pen department. Oh, কি বললাম কোনখানটা? Appeal and the appeal application shall.
We understood the trial court as well as the application shall be taken up for
Trial court na. That the appeal and the application.
The application shall be taken up for final decision on the next returnable
Date. Full stop. Next para. Affidavits, if any, shall be filed by the respondents within a fortnight. Within a fortnight from date. Full stop. Reply, if any, shall be filed within a week thereafter. The appeal along with the application shall be listed for hearing on February 26, 2025.
Obliged, your lordship.
25th February, at an appeal hearing আসবে bracket with can.
Item number 16, my lord, appealing for the state response. Yes, my lord, my learned senior Supratim Dhar for the petition.
You will understand, use the microphone.
Supratim, learned senior Supratim Dhar for the petitioner, my lord. Somehow his clerks
misplaced the brief, my
lord. Just 1 week.
Please allow us a adjournment for 7 days.
I am 40 minute responding caveat, my lord. A copy may be served, my lord. So that my lord.
Lost the brief. No, nothing can be served only. Whenever they get the copy, as and when. Whichever is earlier. Anyway, learned counsel for the appellant submits that the appellant is in difficulty to move the matter today since the brief has been misplaced from the office of the learned advocate. Full stop. Next para. Accordingly, on the prayer of the appellant, the matter is adjourned till February 6, 2025. Full stop. Next para.
My lordship, next week, my lordship.
Next week is 6th. Today we are on 30th.
All right. Okay. Grateful, my lordship.
Copies of the memorandum of appeal and the connected application shall be served on the learned advocate appearing for the respondents by tomorrow. Tomorrow, bring the brief and give them copies.
Sure.
Yes.
But I am for the defendant respondent.
Matter, Lord, yesterday taken up by your lordship. That
Yes.
matter, the extension was rejected since the affidavit has not been attached to the application. Thereafter, the application has been filed, affirming the affidavit has been filed, affirmed, but that has not been taken into cognizance by the learned trial court and refused to extend the interim order. Your lordship kindly see, this is suit for specific performance.
So without an affidavit, how can there be?
Yes, my lord, your lordship kindly sees, my lord, there is, my lord, my lord, thereafter I filed, I tried to, my lord, sort the, my lord, incorporate the affidavit, I affirm the affidavit, my lordship kindly sees my application once.
Extension application?
No application.
Your original injunction application contained an ad interim prayer also?
Yes, ad interim, yes, no, that is affidavit was there. Ad interim granted in my favor.
So we are on a different footing. If your original injunction application also contained an ad interim prayer,
yes,
then whether we'll consider whether on the basis of that it could be extended.
That was there. That was there.
So
in
that why should the court take a technical view? That may be one of your cases. Extension application was filed before the expiry of the first extension application was filed before the expiry of the.
No, at the very date of expiry. The first extension was made. Though that extension application also missing affidavit.
We are hearing out the appeal itself. We are admitting and hearing out it. After line, the appeal will be heard on the grounds taken in the memorandum of appeal. Full stop. As per previous understanding, the appeal is taken up for hearing now.
Memo of appeal has not been served.
This is
very well. No, because in the last occasion we have not directed you to serve, but indication was given that the appeal itself may be decided tomorrow.
Yes, but since
very well. The appeal will be heard on the grounds taken in the memorandum of appeal. Full stop. Since the scope of the appeal is brief, the trial court records need not be called for. Full stop. In view of the appearance of the respondent through the learned advocate, service of notice of appeal on the respondent is also dispensed with. Full stop. The appeal itself shall be heard along with the connected application on February 5, 2025 when the matter shall be placed under the heading hearing. Full stop. Copies of the memorandum as well as the application be served on the respondent by the appellant by tomorrow.
Interim order copy.
What happened?
I prayed for Milord interim order. Why Milord? I am for the Milord. I am possessing there. I'm
No,
possessing the property, Milord.
Let them evict you by 6th. Let us see the
No, Milord.
zeal of
That is
Mr.
why, Milord, I filed
If
this
they can evict
application.
you by 6th, I mean, then they would have done it.
I will satisfy your lordship. There is Milord, the provision in the
Mr.
court,
Mr.
Milord.
Bonik, if
It's,
they were so prompt, then the order was passed when?
11 September 24.
From 11 September 2024 till date, they have
no,
not been able
we,
to.
we moved before the honorable vacation bench.
Whatever.
That matter
you,
was.
you are without any interim order at least since last September.
Yes.
If they could not evict you in the meantime, they would not be able to evict you in 6 days.
At least Mr. It is there.
Mr. Mukherjee is very, he won't be able to do that.
Yes.
He doesn't have the resources to do that. Yes, he's enabled. Okay. 6/18. That's
I appear for the appellant.
Right.
For the respondent.
Very
My lord, I had served, but my lord, the affidavit of service, my lord, we have not received. My lord, I have lodged a caveat. My lord, that's the difficulty. I don't want to do it because they were on caveat. Affidavit of service is lost, my lord. I'll give him once more, my lord, a copy, and then lordship keeps it 5th or 6th because the my lord in the trial court, the next date is on 10th of February.
No, 5th will keep it on 5th.
I'll give him right, my lord, today itself.
Today itself, yes. What is the challenge against?
My lord, challenge against an order dated 27 September by which a notice of AGM of the trust has been stayed by a defendant, my lord, on an application filed by a defendant in the suit. The scope of the suit is completely different. My lord, defendant files an application under 151 asking for stay of operation of, my lord, the AGM notice. In the AGM, my lord, what is supposed to be held? One of the agenda is election. We have no problem even if my learned friend's client participates and my lord
We
conduct.
take instruction on that also in the meantime. Anyway, the appellant shall serve copies of both the applications. There must be a stay also.
Yes, and a condonation, 28 days
Yes,
condonation.
both the applications bearing Can 1 of 2024 and Can 2 of 2024, as well as a copy of the memorandum of appeal on the learned advocate appearing for the both respondents.
But I am appearing only one number 2 because I don't have the copy of the memo. I am appearing for Mr. Thakur Prasad Gupta. My lord, this is against my lord really defendant respondent number 2 because he has obtained the order. The other party is bank, my lord.
On the caveated respondent number 2, no, then you have to serve
I will serve Indian Bank also. If lordship wants, I can, since I am getting
no,
some
section
time,
5 you cannot allow on
yes,
this.
I will serve him also.
As well as the respondent number 1 and file an affidavit of service on the next returnable date. So then we cannot keep it on 5th.
My lord, it's Strand Road. By hand, my lord, I can serve, my lord.
Very well. The matter shall be listed under the same heading on, we are keeping it on 6th.
6th, lordship keeps it on.
Be under the same heading on February 6, 2025.
Grateful, my lord. My lord, I appear for the appellant, but it would be difficult to move it again, my lord. There is a death. My lord, the plaintiff has died. We come to know, my lord, I have to take steps. Lower court, I know, my lord, an application has been filed, but the bench is vacant. So it's not, my lord, complete there. Here, my lord, I have just received information. I'll take steps. This will take some more time, my lord. If
no, we'll put it out of the list with liberty to you to mention whenever you file that substitution application. Because prospectively we can. Learned counsel for the appellant submits that in the meantime, comma, the appellant has learnt about the demise of the plaintiff stroke respondent, sole plaintiff stroke respondent, full stop. Accordingly, to enable the appellant to take appropriate steps to implead the heirs and legal representatives of the said deceased, comma, let the matter go out of the list for the present with liberty to the appellant to file appropriate application and to mention the matter for inclusion in the list as and when such application
just
is
to
filed.
expedite the process, may I pray for one more, my lord, one more sentence, my lord. If you can give us a copy of the death certificate with the particulars of the heirs. My lord,
The learned advocate for the respondent shall furnish the particulars of the date of death of the sole respondent as well as the details of the heirs and legal representatives left by the said deceased to the learned advocate on record for the appellant by tomorrow.
Very grateful.
Please, Your Lordship, not Order 43, Rule 1L, appeal against allowing of Order 22, Rule 10. Now, in a suit for partition, the parties who had gotten themselves substituted by way of intestate succession upon the death of the original plaintiffs. I am defendant number 6, a purchaser of a portion of the properties admittedly and therefore in the array of parties. It's my appeal. So the co-plaintiffs
not added.
No, Lord, they were added. Order 20 Rule 10 allowed in favor of third parties against which I have come up. I am D6.
No. You are a subsequent purchaser.
I am a subsequent.
After the institution of it was a partition. It is a partition suit.
It is a partition suit, but the property in question, according to me, is not common. But then that is a question to be gone into in trial.
Preliminary degree not yet passed.
No, I am no, yes, not yet passed. I am defendant number 6 already impleaded.
Oh, achha, you were previously
impleaded. Yes. 3 third parties have been impleaded in place and state of the original plaintiffs
because they have sold. That
because they allege that they claim by a will of which probate has been obtained, in which consent has been granted by the substituted plaintiffs who have in the meantime been substituted due to intestate succession. Earlier substituted due to intestate succession.
Yes.
Subsequently, allegedly 3 parties have obtained their consent and obtained probate of a purported will in which they are beneficiaries. No deed of assents made.
What is your challenge then?
My
you have
challenge
not challenged the probate.
Yes, I have. I have gone to the probate court. I have challenged the probate. I have filed applications for revocation. I have said it's fraud. It couldn't have been done. Before the Order 22 Rule 10 court, I pointed out that fact. I further point out the fact that the very same persons who have earlier gotten themselves substituted as co-plaintiffs by virtue of intestate succession have, without disclosing this fact, gone to that probate court and given consent for tested grant. And both these
don't understand. The substituted parties are substituted plaintiffs.
The substituted parties are now Order 22 Rule 10 has been allowed.
No, not them. The intestate successors.
Yes.
They were successors of the plaintiff.
They were successors of original plaintiffs, intestate successors.
So you
now the claimant
you mean to say that the sale purported the will. Yes.
By the will,
by the will some third party got it.
By the will some third party got it.
Yes.
And that third party in that probate proceedings that they have filed consent affidavits of the intestate heirs.
Yes, they can do that because they would be the citees.
Yes, they would be a citees, but these citees are persons who have gotten themselves substituted, impleaded here as intestate successors.
Not. I mean, they can be expunged also. I mean,
intestate successors.
They did that, but even suppose at the point of time when they were impleaded, this will was.
That is not their case. I brought the pleadings on record of that also.
If there is a will, Mr. Banerjee, then
211 it goes to executor.
Then the legatee has to come in.
If the legatees have to come in, then that will has to be an unchallenged will up to now. There's a challenge pending on the ground of fraud.
Challenge does not vitiate the existing probate.
But your lordship will.
They are necessary parties to the suit as of today.
They might be necessary parties as of today had there not been any fraud. Lordship will only look into the aspect of fraud, nothing else. I get
fraud in this. They are being the intestate successors coming in the suit as substituted plaintiffs.
Yes.
So that may be a fraud, but this is not a fraud. That the implement of the intestate successors could have been an erroneous thing.
They themselves applied saying there is no will and therefore please substitute.
They might have come to know of the will later.
That is not the case made out even there.
The probate was granted later on.
Probate was granted much later on.
Then,
but they have not made out that case there. I will just show before your lordship. Lord, may I just serve and come? Your lordship need not send this for the purpose of paper books. On the returnable day, my lord will decide one way or the other. I am aware of what is going to your lordship.
Why should we admit the appeal at all, sir?
My lord, as far as this is concerned, only for the purpose of testing whether a party can change his stand subsequently. In respect of a will which is highly contested, as in subsequently proceedings for revocation have been filed. And those proceedings are pending. Their matter has come up before this honorable court. They applied for challenging the maintainability of my revocation proceedings. That application has been dismissed. From there, the matter is now resting before this honorable court. So it's not an open and shut case of a will.
All right. The appellant, how many appellants?
One.
The appellant is defendant number 6 in a partition suit, full stop. The present appeal arises out of an order whereby an application under Order 22, Rule 10 of the Code of Civil Procedure has been allowed, comma, thereby impeding certain alleged legatees of the purported will of the original plaintiff in the suit. Full stop. Next para, learned senior counsel appearing for the appellant argues that the successors in interest of the original plaintiff, comma, the alleged testator, comma, got themselves impleaded as parties to the suit on the strength of intestate succession and thereafter resiled from such position and granted consent to the grant of probate to the newly impleaded party. Full stop. Next para. A revocation case is also pending in respect of the said probate at the behest of the present appellant at present. Full stop. In such circumstances, comma, it is hinted that a fraud might have been practiced inasmuch as the intestate successors, comma, after having impleaded themselves as parties to the partition suit on the strength of such intestate succession, comma, could not in the same breath, comma, blow hot and cold and grant consent to probate of a will executed by their predecessor. Full stop. Next para, the appeal is required to be heard on the above questions as well as the other grounds taken in the memorandum of appeal. Full stop. In view of the short conspectus of the appeal, comma, the trial court records need not be called for. Full stop. The appellant shall serve copies of the appeal as well as the memorandum of appeal as well as the application on the respondents, indicating only on the substituted respondents. No.
The plaintiff would also have to be served.
Plaintiff say.
So সবাই কি করতে হবে?
Partition suit all will be affected.
তো সবাই কি করতে হবে?
On the respondents, indicating that the appeal along with the application shall be listed for hearing on February 19, 2025, when an affidavit of service to that effect shall be filed. Full stop. Let it be understood that the appeal shall be heard on the papers already on record without preparation of any paper books.
No, we'll be at liberty to hand up any if other papers are not, because the C application may require some other papers.
Liberty is granted to the parties to hand up, to rely on upon prior circulation with the other side, comma, further papers, comma, if relevant
in the
for the adjudication of the appeal.
There's a kindly grant a limited stay till 19th. There's a next date. There's a next date on 10th for framing of issues. Then it proceeds. Permit us to apply for adjournment. Kindly grant us liberty to apply for adjournment.
Don't have a case in the appeal.
I beg to appear on behalf of the residents.
I appear for the plaintiff's appellant mallet.
Yes.
This order has been passed mallet in an application mallet in a proceedings under Order 39, Rule 2A. Initially, mallet, a suit was filed for declaration and
Mr. Shen, please come a bit closer to the microphone. Mr. Chatterjee, take your seat.
Yes, sir.
Mr. Shen, please come a bit closer to the microphone or bring the microphone closer to whichever suits. Yes.
Mallet will take the mallet, the application mallet. Application mallet, the plaintiff is annexed mallet at page 11 mallet.
Now, first, let us see the impugned order. How you have violated the
Order 39, Rule 2A proceedings mallet, along with 151 mallet, I have filed an application for interim prayers mallet. That application.
So, your application is under Order 39, Rule 2A. That has been refused.
That ad interim prayers mallet that were pressed for mallet that were refused.
What ad interim prayer?
Mallet, for the implementation of the order order passed by the learned.
Is that available?
Mallet,
it's not available.
Mallet, standing a little bit.
Yes, now understood. No, Mr. Sharma.
My lord, so far as the order, my lord, passed under order 39 rule 2A, my lord, it's an
Is order 39 rule 2A dismissal also applicable? I'm not sure.
Not an order.
Let us check that. I'm not sure.
39 rule 2A is applicable.
2A, if order is passed, it's applicable. Any order passed, I'll just check.
An order passed.
An order under rule 2A. Very well. Let us see order 39 rule 2A. CPC din naki, sorry.
An order under rule 2A.
Yes, very well. Now, interim order was implementation. That is under 151.
The other problem is, my lord, 151 is what separately not filed, my lord. It's in a miss case. So order 150 doesn't lie. But so far as the order 39 rule 2A, my lord, say it should be registered as a miss case, my lord. That was filed, my lord. My lord will take my application, my lord. It is appearing, my lord, at page 57.
If the 39 2A was dismissed,
No, dismissed, no.
or finally disposed of, then it would be applicable.
But an order passed, my lord. It's not the final under 2A. Under 2A.
Under 39 2A, rule 2A, 39 2 rule 2A is an order for disobedience.
This is not an order under 2. It is in a proceeding under 2. I don't know, 144 will come into play.
What is that interim refused? You sought for implementation.
Well, to allow the to not allow any player, cricket player, to be fielded under Mohanlal Club in any cricket tournament having registration card.
That is an independent injunction sought in a.
No, injunction was passed. Malad will.
Yes, why did you ask for this? You have not sought for implementation.
Malad, but in effect, it is a prayer for implementation. Malad will kindly consider, Malad, the order passed in the suit, Malad. That is at page 54.
No, let us see the prayer now which has been refused.
That is at page, application is page 57.
Injunction has already been granted. Why are you asking for another injunction? Injunction is already there.
In effect, Malad, the prayer, Malad. So
ineffective, not ineffective.
Whereas the prayer, Malad, the couching of the prayer is little bit.
Ad interim injunction you have asked for. Restraining self-same relief has granted to you on the strength of which order 39 rule 2A has been filed.
Most probably, Malad is going through the order passed by the learned tribunal.
Yes.
Malad will kindly consider.
So show us a prayer. Yes.
Page 62.
62. Not to allow any cricket player to be fielded. That is the original injunction you got.
Original injunction, Malad will take Malad page 50 at page 56, Malad. Considering the urgency, there is nothing impediment in allowing the interim relief restraining defendant numbers 1 to 4 and their men and agents from interfering with respect of the participation of players admitted by the plaintiff petitioner herein, and the interim order will be effective till the next date. That was the interim order passed in the suit, Malad.
From interfering with respect to the participation of the players admitted by the plaintiff hearing. So your players were permitted to participate.
My lord. Rather, the defendant numbers 1 to 4 were restrained.
And now you ask for an injunction to not allow. To not allow means a restraint order. Any cricket player to be fielded under.
My lord, now
so this is a new injunction you are seeking in the 39 2A. And if you seek it in 39 2A in a miss case, then that's not an appealable order. This is the new injunction you are asking for.
But
First of all, it is beyond the scope of 39(2)(a).
But in that,
This is not in implementation of that.
but so far as the if my lord holds, my lord, it's not an implementation of the original order passed under order 39 rule on 2A, my lord. It's order 39 1 and 2, my lord. That's a different thing. But so far as the I will be humbly praying, my lord. So far as the my lord will go by the order passed in the suit, my lord, and the
Yes, suit order is very clear.
My lord,
Your
I was-
players will not be restrained from
effect,
being
my lord,
fielded.
I was praying for implementation.
You are
of that,
Mohanlal Club.
my lord.
You are Mohanlal Club. So your players have been no, but on that premise it has been passed. Now you are Mohanlal Club. Your players have been permitted to participate in a sense, in a double negative.
My lord.
They cannot be restrained from participating. And now you say to not allow any cricket player to be fielded under Mohanlal Club in any cricket tournament, having registration bearing the signature of the respondent, Devrutapal. That's a new injunction
My lord
altogether.
will kindly come to page 67, my lord. Only one page, my lord. But what they are doing, my lord, the defendant number 2 in the suit, my lord, is, my lord, putting up players, my lord. That is the registration slip, my lord.
Mr. Shen
Under
will
the-
just come back in 5 minutes and we'll decide this. Thank you. Yes, Mr. Shen, how does it come within that violation of that injunction?
So far as violator has been passed at page 56.
56. 56 says that, yes, what you placed, yes.
Malad, and page 62, Malad, we have played the interim order in the order 39 rule 2A proceedings.
Right.
So far as this is concerned, Malad, in my humble submission, Malad, this is the only way that the wrong that is being perpetuated can be stopped, Malad.
Why we say no, we are explaining to you, Mr. Shen. This does not necessarily mean that your people will be permitted to enter. That does not necessarily mean that others won't be permitted to enter, unless you had a specific injunction to that effect. This injunction, these are not mutually exclusive.
Page 67, Malad will call you consider, Malad.
The injunction order does not restrain them from doing it. I mean, what you have prayed here, your injunction order does not restrain cricket players to be fielded bearing the signature of Devabrata Pal. And that is the reason why you had to pray for this negative order.
At the same time, Malad, I will be saying, Malad, if Devabrata Pal, Malad, defendant number 2, Malad, goes on doing such things, Malad, then
their players will also go, your players will also go as per your injunction obtained. There is no restraint on that, Devabrata Pal.
Devabrata Pal, it amounts to interfering with the affairs of the club, Malad. That is, Malad, they have been restrained.
Mr. Shen, this is a lose-lose situation for you. If you say that this interim relief is covered by your original injunction, then there would be no necessity to ask for this restraint order.
Restraint order.
And if you say it is not, then this is a new prayer which is beyond the scope of Order 39 Rule 2A.
My humble submission will be, Malad, by passing the order prayed, Malad, under Order 39 Rule 2A, Malad, at page 62, Malad. This is the only in the this order. By passing this order, Malad, the effect enforcement of the order can only be made, Malad. Because, Malad, the interim brief restraining the different numbers 1 to 4 and main and agents from interfering in respect of the participation of players admitted by the plaintiff petitioner. Now, Malad, he is also signing as the secretary and Malad putting up players.
He is not prevented by any order from doing that. You only say that your players, if they stopped you from participating, your players from participating, we could have understood. They're not doing that.
Club will have only one set of players. But I will
maybe 5 players from your camp and 6 players from their camp. May very well, as per your injunction, that it is permitted.
But
there may be even 1 player from your camp.
Amounts to interference in the so far as my injunction is concerned, Malad.
Even if there is interference, then no. This is a new injunction you are asking.
But so far as the injunction in this sense,
you could have gone to the suit court and obtained this additional injunction.
But in that
and this could be the only injunction you could have asked for, or composite. Your players won't be restrained; their players would not go in.
But so far as the defendant numbers want to, Malad, in my humble submission, it was included because interference was it has been injuncted from interfering with respect of participation of players admitted by the plaintiff petitioner.
Their introduction of their players does not amount to interference of your players being included. You can still have your players in the team too. There can be both Devabrata Shah's player or Devabrata Pal's players and your players. The team is comprised of 11 and with extras 13.
But 30 players can be inducted, Malad.
30?
30, Malad. No, Malad.
15.
Malad, all 30 have been inducted by his signature. In effect, Malad, my injunction, it's of no use, Malad.
If you say that, then there is this has spent its force. If all 30 players have been inducted,
Malad,
then this injunction cannot be allowed now because he has already inducted.
No, Malad. It's an ongoing process, Malad. Ongoing process, Malad. Every month, Malad. Every season, Malad, there are
this injunction, your injunction at best prevents them from preventing your people from going in, but does not prevent Devabrata Pal's people also coming in. Both of your players, as per the present position, as per this injunction order which you have obtained from the suit court, both of your players can come in. There is no bar to their player coming in.
Malad, their role has been restrained by the injunction order. My submission is that.
Their role in interfering with your players coming in. Can you say your players can still come in?
Malad, that is their, Malad. My players can come, but at the same time, Malad, the restraint order is upon them. Malad, they cannot say, Malad, they are the honorary secretary and they are putting up players, Malad. That is the difficulty, Malad.
The specific injunction order, then you have to obtain a specific injunction to that effect.
But
That they cannot claim themselves to honorary secretary or they cannot induct players. You have not asked for that in the garb of Order 39 Rule 2A, you are wanting a new injunction.
But my submission is, my lord, Order 39 Rule 2A is concerned, my lord. This is the only manner, my lord, by passing this order, enforcement of the original injunction order can be made.
You dismiss the appeal. On what ground it has been dismissed?
Well, in fact, my lord, Order 39 Rule 2A, my lord, the findings of the learned tell that in effect, he has decided the Order 39 Rule 2A itself, my lord. Well, the first point, my lord, the first reason ground.
Yes.
The restraint order number such and such is clear and unequivocal, which states that the defendant numbers 1 to 4 and their men and agents are restrained from interfering with the respective participation of players admitted by the plaintiff. No interim order has been passed stating that the defendant shall restrain from fielding players after registration under Mohanlal Club in the cricket tournament.
Precisely.
But so far as the defendants have been restrained from putting up players, my interim order is that, the interim order passed. In effect, by passing this observation, my injunction itself goes,
No. We agree with one. No interim order has been passed stating that defendant shall be restrained from. We fully agree with one.
But defendants shall be restrained from fielding players. But that is the.
If an interpretation of the injunction order is necessary, it is not a case of Order 39 Rule 2A or contempt for that matter. Same principle as contempt applies.
My lord will kindly consider the interim order. Interim order interfering with respect of participation of players admitted by the plaintiff petitioners herein, and interim order. This is in respect of interfering with respect of participation of players. This amounts to that, my lord. Interfering in respect with respect to the participation of players admitted by the plaintiff.
No, similar prayer court says has been prayed in your suit also, in your injunction application also.
But that is this prayer there.
That is, where is the main injunction prayer? Show us that. Yes, page 20 must be in line with that. No, that is wrong. And also restraining, yes.
That's not wrong.
That was not granted to you.
Not granted. He prayed again. That also was not granted.
No, past.
In the 23 season, not kindly excuses me, but I just have one copy.
23.
In the 23 season, they prayed for the same thing. You know, in the suit.
Maybe.
In the suit. That was refused. Now, Milord, they
But
go,
in this order also, the injunction which you are relying on, that prayer has not been granted.
not granted.
No,
No, Mr. Shen, nothing.
That prayer was not made, my lord.
And also,
Yes. Come to page 20.
For permanent injunction restraining the
Read it.
numbers 1 to 4 and each
That
of them claim in
And also read from and also the last four lines. And also restraining.
restraining the defendant numbers 4 and their
Precisely what you are asking for.
interfering with the in respect of participation of players.
and Milord, on the
Admitted by the
No. And also the last three lines of C. And also restraining defendants recommended players from participating.
any authority before and now.
And on the contrary, Milord, he has been injuncted not to, Milord, interfere in the business of the club. In a separate suit.
Will not say that in. We will not admit the appeal. Will dismiss under Order 40 Rule 11. The present appeal has been preferred against an order whereby the plaintiff stroke appellant's ad interim prayer, allegedly for implementation of an injunction order granted in the suit, in connection with the proceeding under Order 39 Rule 2 capital A of the Code of Civil Procedure, has been turned down. So next para, learned counsel for the appellant places reliance on the injunction order dated February 15, 2021, passed in the appellant's suit bearing title suit number 222 of 2021, whereby the defendant stroke opposite party numbers 1 to 4 and their men and agents were restrained from interfering with respect of the participation of the players admitted by the plaintiff petitioner, and the interim order was to be effective till the next date. Push up next para. Learned counsel argues that by virtue of the ad interim prayer in connection with the Order 39 Rule 2A application for complaining of violation of the said order, the plaintiff stroke appellant sought a restraint order on the defendants from fielding under the Mohanlal Club in any cricket tournament, any cricket player having registration card bearing the signature of the defendant stroke respondent Devrobroto Pal. Full stop. Next para. It is argued that the only way in which the injunction order obtained by the plaintiff could be implemented is by virtue of the said ad interim prayer small b as made in the Order 39 Rule 2 capital A application. Full stop. Next para. It is also submitted that the materials on record show that the defendant respondent Devrobroto Paul is seeking to induct his own players in the cricket team under the name of the said club, thereby frustrating the effort of the plaintiff to include its players. For sub next para, we find from the records, however, that although in the temporary injunction application filed in connection with the suit, the plaintiff had specifically sought injunction not only in terms of the ad interim order granted in its favor, but also further injunction restraining the defendant apostrophes recommended players from participating before any authority in any manner. Full stop. However, while passing the ad interim order, vide order dated February 15, 2021, although the first relief sought in the injunction application was granted by the trial court, the second relief regarding restraining the defendant from its recommended players participating before any authority was deemed to have been refused, since not granted. Push up next para. Thus, in the garb of an ad interim prayer made in connection with the application under Order 39 Rule 2 capital A of the Code of Civil Procedure for implementation of the interim order granted to the plaintiff, the plaintiff stroke appellant is seeking to reintroduce the relief which has already been deemed to have been refused by the injunction order dated February 15, 2021. Full stop. Next para. Moreover, seen from a different perspective as well, the injunction order granted in favor of the petitioner by the suit court, in favor of the appellant by the suit court, is merely to restrain the defendants stroke respondents from interfering with respect to participation of the players admitted by the plaintiff. Full stop. Such restraint order is not mutually exclusive with the defendant Devrobroto Pal also including his players under the name of the club in the cricket tournament. Full stop. Next para. As such, prayer small ad interim prayer small b of the Order 39 Rule 2 capital A application is in no way connected with the implementation of the injunction order obtained by the plaintiff, but is an independent relief which was refused in the suit itself. Full stop. Thus, the learned trial judge was justified in holding that no injunction order was passed restraining the defendant from fielding his players after registration under Mohanlal Club in the cricket tournament. Push up accordingly, on the grounds as attributed in the interim order, as well as on the additional grounds as supplied above, we are of the clear opinion that there is no illegality and or irregularity or erroneous exercise in the impugned order dated January 9, 2025, whereby the petitioner's ad interim prayer in connection with the Order 39 Rule 2 capital A application was turned down. Full stop. Hence, FMAT This is 35. 35 of 2025 is dismissed under Order 41 Rule 11 of the Code of Civil Procedure. Consequentially, can 1 of 2025 also stands dismissed. There will be no arrest to cost.
Grateful.
Thanks. Yes, Mr. Vas. Paper book.
Mr. Sen has elaborately submitted this.
Yes.
I at the very outset can I recall I have submitted that it is the interpretation of a document or that is a family settlement or a will. I will only take.
Mr. Basu, would you just please remind us just the because you are taking up so many matters, just confused. Just in a nutshell,
Yes,
just
yes.
remind us. Yes. You are the defendant number 1. If
A suit for partition.
all right.
In the suit for partition, we take a defense that
You are challenging what?
I am challenging the order,
Preliminary.
partition order. Preliminary.
Preliminary, right.
My defense was that there is a family settlement acted upon, so partition is not meant to be. In that judgment, my lord, I don't know, third case made out by the court and say that it is not a gift.
It was an unregistered family settlement.
Settled. Registered.
Registered.
Only difficulty is, my lord, I can understand the difficulty. My lord has also pointed out that it is a not in present time because the donor himself keeps the property in his care and he in fact sell out some property.
Yes.
Some property. So that's why my submission was either it is a family settlement or a will. So far as the partition suit is concerned, but today if your lordship was pleased to dismiss the appeal, a partition is inevitable. But if your lordship thinks that the interpreting the document is a will and there is no executor, so I have to go back to file a letter of administration. And in that case, I can apply for an injunction that this is a family settlement. I want to only show to your lordship, apart from that now probably it has come to your mercy's mind, that the family settlement or the will execution has been admitted.
Yes, registered deed is there.
Registered deed, no, execution has been admitted. I am so plus 1 75A bodai, na 60A, 117. Yes. But I will place only one. People of can you take up the paper book?
Yes.
117.
Years.
Third line. The defendants number 1, 2, 4, 5, 6, and 7 brought 2 attesting witnesses.
This is a part of the impugned judgment.
Yes.
Achha.
Impugned deed of gift. Both of them deposed that the Manoranjan Mitra on his own volition gifted the suit property to the defendant number 1 and 2. They remained firm in the face of lengthy and cross examination. Their credit could not be impeached.
Yes.
At least in regard to the question of voluntary action of Manoranjan Mitra in executing the impugned deed. The question of registration of the deed at a different place or at the place decided by 2 or daughters of the Manoranjan Mitra is not a pivotal significance so as to disbelieve the deed solely on that ground. Since DW 1 and 2 unequivocally declared from the witness box that Manoranjan Mitra executed the deed in favor of the defendant number 1 and 2, I am of the opinion that the execution of the exhibit A by Manoranjan Mitra cannot be under any shadow of doubt. This is all the more so as the defendant number 1 and 2 deposed in favor of the deed of their own detriment, since if the deed was to be declared void, they would stand to gain by virtue of inheritance from their father.
So our declaration was also sought declaring that deed to be void, that registered deed to be void.
Yes.
That was the first declaration, then partition.
No.
It was the third
declaration.
Anyway, yes.
But I want to, my lord today cannot decide that one. I want to show to your lordship that if this is the evidence, then the plaintiff also accepted the execution of the document.
Yes.
Execution of the document. What is the document? My lord has to decide.
Yes.
If my lord is of opinion, no, it is not a deed of settlement, not in presenta it was transferred. The stipulation is there after the death.
What will be the position, Mr. Basu will also have to clarify as to a will which has not been probated or
No, nothing.
state of administration.
Bare paper. Now only
If it's a bare paper, then on the strength of that, can you seek?
no, I'm not thinking. That's why my submission is, my lord, it is probably I don't know whether my lord has come across such a position. I have not come across such a position. My only prayer would be if my lord ultimately holds no, this is not a family settlement, this is a will. Then I will be praying for an adjournment of this hearing so that I can approach the learned court below for a letter of administration with an application for stay of the status quo in respect of the properties, subject to hearing by learned
So
court.
if we hold that, then Mr. Basu will give you liberty to approach because it will be ex debito justice, not under section 10.
No.
Because probate court is not competent to grant this relief.
No.
So therefore it would be ex debito justice. There are cases where that has been granted. Then we'll give you liberty to
approach.
We are just discussing.
Yes.
Approach the trial court.
And this is my endeavor to pursue lordship to that date indulgence. Because according to us, it is a family settlement in percentile, though he has said kept. But
so let us see the deed first.
My lord, the deed has my lord has seen.
Yes.
Seen that, and
yes.
The judgment which is cited by my learned friend, that is distinguishable on facts because there was a stipulation that during the lifetime none will be able to sell or transfer the property. Here the distinction is there. That's why that judgment in so many words cannot be applied in this case. That Mohanram judgment.
No, family settlement, there has to be a present vesting of right. It can take effect in future.
But here,
here rather
reserve the right. Not only that, this fact of the case, he sold out some portion of the right.
Exactly. So if you reserve the right to transfer, then there is no present vesting.
Not at all.
It's not a vested right.
I can't say this.
So it has to be only a will.
Yes. But the court make a third case. That is not a gift. So the partition should be there. But now if the division bench of this court is of the opinion that no, it is a will, then I have to take recourse to.
But there is a will, there is a way.
That way I want to find out.
So let us hear Mr.
This is the thing. Mr. Sen has elaborated.
Yes, he has elaborately and quite.
First time I was
about all the points.
And I was ill, could not come to court.
Yes, Mr. Rai.
My lord, the case, my lord, of the appellant before lordship today is that the court was wrong in not reaching the conclusion that it is a will. My lord, I would start by submitting this, my lord, that for the court to reach a conclusion, my lord, a proposition has to be made. My lord, your lordship will kindly see, my lord, what was the proposition made by the defendants, my lord, in the written statement, because they were defendants in the suit. My lord, before the court, the case run by them in the written statement was that it is a family settlement.
Your case was that it is a deed of gift.
I also said, my lord, that it is a deed of settlement. And my lord, I said that it is void on certain grounds. My lord, the defendant, my lord, in the written statement said that it is a family settlement. At the argument, it was pointed out by the defendants that it is a deed of gift. My lord, the court went on to, my lord, check as to whether it was a valid gift or not. And my lord, the court held that it is not a gift. My lord, that was
but
the
Mr. Rai,
yes.
After this could have been a consideration at the initial stage, what stand has been taken by the parties. But after the evidence is before the court, parties lead evidence, and it's only a question of interpretation of the document.
Lord, it was not the question at all, my lord, because
it's a question of interpretation of the document.
It was argued by them that it is a deed of gift. That was the argument. My lord, nobody said that it is a will. My lord, the court did not make out any case at all. My lord, it's better known to your lordships, my lord, that if it is the case made out, my lord, or sought to be made out before your lordship, that's something which has been argued, has not gone on correctly.
So you say you are right. The court cannot make out a third case.
Yes.
But this is not exactly a third case. This is an interpretation of a document which is before the court. Both parties say different things. You say it's a settlement, and they say it's a gift. So both of you interpret it wrongly. And suppose the court finds that it's a will. It's evident that it's a will.
Court did not find it's a will. Court said it's not a gift. Court
right.
said not that
even if it's not a gift, the court should have gone a step further. I mean, the document is before the court. It's a mere question of interpretation.
Lord, even then, Lord, because it was my suit, I sought, Lord, for a decree of partition, Lord. If Lordship sees, my Lord, the manner in which, my Lord, the court has derived it, my Lord, I think, my Lord, that would satisfy my Lord's conscience.
So as of today, as you say, when the partition, the impugned decree was passed, Till that date, there is no application even for a probate also.
No, no, not at all. My lord,
So there was no impediment in passing that.
And my lord, the defendant ought to have shown it to the court that I believe it to be a will. My lord,
Yes,
my lord,
that was never done.
That was never done. My lord, today, my lord, after the decree has been passed, my lord, having lost on that score, my lord, if the defendant becomes wiser, my lord, he is
And
wiser.
if they, even if they become wiser, their remedy can be at best to approach the trial court after the preliminary degree even to seek a stay or whatever. We should not give a stamp to that.
No, not at all, my lord, not at all, my lord. I would have, my lord, I would have beseeched your lordship, my lord.
Because if a letters of administration or a probate is granted ultimately, considering this to be a will, then the entire thing would have to be reopened.
Yes, yes. And my lord, it was their obligation, my lord, to prove the will first. It is only then, my lord, that the court would consider this.
The court has observed, Mr. Basu showed that it is an admitted, the execution is admitted.
The execution, my lord, yes, the court has observed.
For the purpose of the partition suit, that was sufficient.
Yes.
You have admitted execution.
Yes, my lord.
But for the section 63 has to be satisfied in probate proceeding.
Probate proceeding.
Not in this proceeding.
In what context this execution, my lord? If your lordship sees, my lord, page 120 of your lordship's brief, my lord. Page 120, when the court, my lord, goes on to elaborate. My lord, this is what is, my lord, what is very important and which should have been brought to your lordship's notice.
Yes.
My lord, page 120, last paragraph.
Right.
In this suit, the legality and validity of exhibit
This
A.
was probably placed by Mr. Shen.
Yes.
Yes. Anyway.
If, however, my lord, the third line, if, however, the said deed cannot be sanctified, the property would devolve upon all the heirs of Manoranjan Mitra following the rule of Hindu succession. Therefore, my lord, this was in the mind of court.
Cannot be sanctified, that we mean.
Lord,
what is sanctification?
Lord,
Grant of probate is sanctification.
Lord, in the nature, my lord, with the defendants wanted the court to believe. My lord, the defendant said it's a deed of gift. The court, my lord, analyzed and said it is not a deed of gift because, my lord, there was no transfer. My lord, there had to be a transfer.
No, there was a question of it being a deed of gift. We don't know why they took the point. Even Mr. Chen does not know why he took his client took the point.
And my lord, in the written statement also, my lord, it's family settlement in writing. My lord, it's not that something, my lord, if your lordship kindly.
But the nature of the deed, Mr. Rai, is not merely a question of a pleading. It's a question of interpretation of the document also.
Yes.
So suppose a lease deed is an eviction suit is filed on the basis of a lease deed.
That is very important, Lord. Here also an eviction suit was filed by the defendant, Lord.
Yes, and the court interprets that no, it is a license. Court can do that even if the defendant does not take that point.
Yes, that's definitely there, my lord. That's definitely
it's a question of interpretation.
Because there, my lord, it would have my lord, the eviction of the party, my lord, was dependent on that. Here, my lord, both the parties, my lord, suggested that it was a settlement. Another party, my lord, suggested that it was a gift, my lord.
No, there's a difference. If it's a will, it takes effect posthumously from the date of the death, retrospectively subject to probate being granted or later heard.
Yes.
So it's not an invalid document in the sense that it does not devolve title. It may be invalid as a gift deed. It may be invalid as a family settlement.
Yes.
So it's neither a family settlement nor a gift deed. But it may very well be a third genre of document,
correct.
Which is a will.
So
if that finding is there, at least they'll have that option to go before a probate court or whatever.
My lord, that your lordship, I will beseech not give the liberty today, my lord, because that would be barred by limitation today, my lord. I have, my lord, important rights. They will avail their remedies, my lord, before the court.
Limitation in grant of probate.
Yes, my lord. It's 3 years, my lord. Supreme Court has held, my lord, that it's
3 years from what?
From the death of the testator, my lord. There are a series of judgments, my lord, which said that, my lord, when the right to sue applies. Right to sue accrues.
Right to sue accrues,
Lord,
but once it is interpreted by the court, by this court, that it's a will, that will be the first time.
I'm beseeching your lordship not to do that, my lord, because this exercise was never done, my lord. This exercise was never, the court was never called upon to do this exercise. If your lordship
court need not be called upon, we can always, because you both of you say that it's an invalid document. They say it's a valid document. Gift deed was a ridiculous, absurd proposition.
We had also, my lord, taken the ground of.
You are the plaintiff. You say that it's a family settlement. You label it as a family settlement.
We label it as a deed of settlement, saying that it has been forged. It has been fraudulently obtained.
But fraudulently, you have admitted execution in your evidence.
My lord, we have not admitted. My lord,
so that's the defendant's admission. But the court's finding is it's an execution is admitted.
The court says that execution.
Manufacture, you have not adduced any evidence to show it is manufactured.
No, my lord, we have, my lord, if your lordship kindly sees, my lord, our argument.
Argument may be there, but forgery manufacture, this has to be clearly, particulars have to be given.
Things we have.
Court's finding is not there.
Yes, that finding is not there, my lord, under Order 41 Rule 33, my lord. While supporting the decree, my lord, I can always, my lord, urge your lordship
You
to
can
take it, my
urge,
lord.
but if the materials are not there, I mean, where are
My
the
lord,
materials?
I'll show the materials, my lord. The first material which I would show to your lordship is, my lord, the place of registration. If your lordship sees not, that is why I wanted to take your lordship, my lord, through the arguments, my lord, because those will, my lord, help me in framing my points. If your
All
lordship
right.
kindly takes, my lord, page.
One zero for the arguments begin.
Yes.
Or whatever the decision.
Lord, if lordship takes, my lord, page 109.
Yes.
No, I'm not saying about the eviction. Page 109, my lord. My lord, Lord, ninth line from the top, my lord.
Yes.
After Exhibit A, he pointed out.
He pointed out,
that
yes.
the deed in question never stated that it was a deed of gift, even though the defendants are clamoring by saying that by virtue of the said deed, Manoranjan Mitra gifted all the land in the suit plots to defendant numbers 1 and 2. It is very clearly written at the very first page of the deed that it was a deed of settlement. He stated that in the last page of the deed, it was
So
written that
it's
there were
your
two-
case that it is a deed of family settlement.
No,
This
no,
is
it
your
was-
argument.
Yes, because in the deed itself, it's written family settlement.
But that is the finding of the
Yes. He stated that in the last page of the deed, it was written that there were two maps appended to the deed, which were to be considered as part of the deed. However, no such map was produced before the court by the defendants. Learned lawyer for the plaintiffs requested the court to draw adverse inference against the defendants as they suppressed material facts. Thereafter, he expressed his wonder as to the validity of the deed by saying that if at all said deed was a gift deed, how could Manoranjan Mitra sell the land to Meena Ghoshal afterwards?
It was a
According to
bad
him, the property once divested cannot be vested. Thereafter, my lord, kindly take, my lord, page 110. My lord, he also drew my attention to Exhibit E, being the deed of sale executed by Manoranjan Mitra in favor of Meena Ghoshal by saying that nowhere in the recital of the deed the fact of execution of Exhibit A was disclosed. On the contrary, at page 3 of Exhibit E, it is clearly written that the property transferred to the said document was never transferred to any other person. Learned counsel for the plaintiffs contended that the impugned deed was very suspiciously registered at the office of ADSR Ranaghat, while the suit property was situated within the jurisdiction of the office of the ADSR Shagda.
Ranaghat did not have jurisdiction at all.
No.
No part of the property. It is not the central office.
Concurrent jurisdiction.
No, that is not apparent from here.
Thereafter, my lord,
It is your arguments.
Most surprisingly, the deed of sale in favor of Meena Ghoshal, through which a part of the suit property was transferred, was registered at ADSR Chakda.
Maybe.
According
both have
to him, these
jurisdiction.
circumstances are sufficient to reach the conclusion that the impugned deed was executed and registered in furtherance of conspiracy. Therefore, my lord, I have made out a case of fraud. Thereafter, my lord,
Nothing comes out from this that they did not have concurrent, or some of the properties fell within Ranaghat jurisdiction. We don't know that from this. This is your argument merely. Order 41 Rule 33 is not so wide. We cannot now interpret evidence and
in the schedule of the deed, the properties, my lord, all of them are situated in Chakda only. All the properties.
the Ranaghat is in the same district.
Ranaghat is in the same district. Yes.
So we don't know whether that office also has jurisdiction. Those facts never came up in evidence.
Yes, that's there.
So on Order 41 Rule 33,
Yes,
everything
that
has to be there.
Yes, has to
We
be
can
there.
only just pass a degree, further degree, or
and then, Lord, page 112, the ADSR Ranaghat, Lord, dispensed with the LTI, left thumb impression. Lord, Lord, from the bottom, 8 lines from the bottom. Pointed out that on the reverse page of the title page of the impugned deed, there was an endorsement of the ADSR Ranaghat stating LTI was dispensed with. Lord, these facts were there before the court. Lord, these facts are there before your lordship also. Lord, it was in this situation, my lord.
The LTI was dispensed. Whose LTI? The executors. Then what, there's no signature.
There was a signature in English. My lord, that was also, my lord, doubted. My lord, because in the evidence, my lord, they said that the my lord, settlor or my lord, the executor, my lord, knows Bengali. My lord, in fact, in the sale deed, he has signed in Bengali. This,
I am
my lord,
also a Bengali. I sign my orders in English.
my lord, he has signed the sale deed in Bengali. He signed the family settlement in English.
Acha.
And my lord, the defendant's witness says that my lord, he knew Bengali. Therefore, Lord, the materials are not so, my lord, less, my lord, so as to infer, my lord, that yes, it was a document, my lord.
But in the absence of any specific finding of the trial court, Mr. Rai, that it was a fraudulent document.
Sanctified. Trial court said, my lord, that they have not been able to sanctify it.
Yes, there is a specific observation of the trial court that this was a fraudulent document, manufactured document. We cannot go by the fact that it was a manufactured document. The document exists. It was not held by the, it's a deemed refusal of that plea of yours, that it's a manufactured document, false document.
No, my lord, kind of, let me mold my argument in this way, my lord. My lord, I go to the court, my lord, I seek a decree for partition. My lord, upon getting this decree, my lord, the court would have granted this decree for partition, my lord, only if the court would have annulled that the deed by which, my lord, they claim, my lord, title to the properties has no validity. That, my lord, the court has done in a way by granting, my lord, the decree for partition to me.
Yes.
My lord, I have got the decree for partition. I do not need, my lord, to challenge that finding, my lord, or to say that the court has not expressly said that the deed is invalid. Because the court has held, my lord, that we have, my lord, the line which I showed, it says that the property would devolve if the document is not sanctified. My lord, court has held that the property has devolved upon the heirs, my lord, because it has not, my lord, found out any other detour. The properties have not taken a different route.
Legality and validity of Exhibit A is of pivotal significance, as in case the same stands the scrutiny of law, the entire situation would be different.
Yes.
And it says the deed cannot be sanctified. If, however, the deed cannot be sanctified, the property, this is a theory. I mean, this is his academic. And what does he say about the deed?
Yes, my lord.
Then he goes on. This is only a discussion of the.
Yes, and then he goes on to discuss, my lord, as to whether it's a gift or not, because that was the case, my lord.
That was the case, yes.
Court. That was the case run. The court finds that it is not a deed of gift, and my lord,
the entire premise was on their case, obviously. It was not a gift.
Yes.
Not a gift, not a gift.
Not
but
a
you
gift,
also made out a positive case. You asserted that it's a manufactured document.
Yes.
And you argued on that was not upheld. So therefore, now you cannot resile from that position and say that no, appeal court, you under order for 233, you appreciate the entire evidence and you say that it is a manufactured degree. And there is no cross objection also as such.
No, there is no cross objection, my lord. But if my lord, my case furthers the decree that I have got, my lord, I can definitely put forward that case. My lord, under order 41, rule 33.
True, but order 41, rule 33, you don't find any material sufficient to hold that it is manufactured beyond doubt.
Lord, even then, my lord, we do not even find that material, my lord, to show, my lord, that there was a case, my lord, before the court that it was a will, my lord, in the manner it is.
There was no case made out that it was a will.
No,
there was no case.
No case made
You
out.
challenge a document.
Yes.
Burden is on you. Owner's shifts, burden remains. So your burden is to show that's an invalid document, because whatever way you couched your challenge to that deed, Mr. Rai, fact remains that if that deed vests some title in a particular manner, you cannot get your partition in the way you are wanting it. So that stands in the way of you and your partition, you getting a partition. So that is a deed which you have challenged. You have couched it in a particular language. You say it's a deed of settlement, not a valid deed, and they say it's a deed of gift. Whatever you label it as, that deed remains. If it is seen by the court has to see, to grant your partition degree, it was a prerequisite for the court to see whether it's valid in any manner. It vests title in any manner.
No, my lord, even a will.
Whether you say it's a deed of settlement, they say it's a gift, whatever. If it was a third genre of document, then also before granting a degree of partition, you have challenged that deed. The court had to come to a specific finding that deed does not in any manner vest any title in anybody.
Lord,
Otherwise, the partition degree cannot be passed. Your degree is dependent on that.
Lord, it does not, my lord, satisfy the test of a settlement. It does not satisfy the test of a gift.
No.
No, my lord, even if it satisfies.
If satisfies some test.
My lord, I'm going a step further, my lord, saying that it satisfies the test of a will.
Then you
Merely
cannot get
because-
your partition degree.
Not merely because it satisfies the test of a will, my lord, I would not be stopped from getting the partition degree.
Preliminary
till such
degree,
time-
yes, you are right. Preliminary degree,
till
because as
such
of
time
today, there is no probate.
There is no probate. And my lord, there is no application for probate, my lord. There is no liberty sought for, my lord. Today in the appellate court, in the appeal, they cannot walk away with that liberty, my lord. It is always with them, my lord. They may approach the probate court if they feel so, my lord. Your lordship will not grant them this blessing.
But this is the first time any court of law is holding that it's a will, if you hold that.
My lord, that is for
So it was a matter of interpretation. Why shouldn't the right to sue ripen when we hold that?
If the party, my lord, who is in possession of the document itself does not know that it is a will, and my lord, the party stakes its claim, my lord, saying that this document is a deed of gift.
The nature
Then,
of
my lord,
the document does not change.
Then, my lord, the
If
party,
you don't know, you have a diamond.
My lord,
You think it's a stone. It remains a diamond.
My lord, for
Effect of
it-
diamond will be given.
But for the stone to be converted into a diamond, we have to go to the right place. My lord, I have not gone to the right place, my lord. In the meantime, such a chemical reaction has happened that
So
it can never be converted.
stone is
into
not
diamond.
required to be converted to a diamond. Diamond remains a diamond. A diamond has to be given some finesse
My lord, for
by the
that
probate
finesse-
court.
My lord, for
And
that,
that is only applicable in some states.
I
If
appreciate-
it was a different state, then they would not need that finesse. A raw diamond would do.
Yes, Lord, but I am entitled to that. I am entitled to that privilege here, my lord, because law of limitation is there, my lord. He will definitely have his case there, my lord, but not by virtue of a lordship's blessings, my lord. This chemical reaction, my lord, your lordship will allow this privilege to me. This bar of limitation hangs high on them, my lord, because this.
But at least we have to satisfy our conscience what is the nature of what sort of a creature is the document.
Yes, kindly have a look at the document.
If the court says that it's not a gift deed, if it's not argued by anybody, it's a will. If we find that it has the characteristics of a will, we can definitely say that. We won't go any step further.
My lord, that
does. No, because you could not, I mean, if there's a will, I mean, there's some doubt it has repercussions on your decree, the declaration of shares also.
My lord, somebody ought to
retrospectively, yes.
Somebody ought to go and take, my lord, take the will.
We are not
further.
granting them probate, nor are we giving them leave to approach the probate court. We cannot do that. But we can definitely interpret the document, which the court ought to have done.
My lord, your lordship will allow me some time to think and come. My lord, I would answer this question, my lord, because this argument I did not expect, my lord, because the case run in the written statement
Correct.
was settlement.
Third case.
The case argued was settlement.
And
The
also,
case
Mr. Rai, you also come prepared on this, whether a court, independent of the name given to a document by both parties, whether the court, after the final hearing, can, on interpreting the document, come to a finding that it is of a particular nature. Court independently can. Because if a lease deed is called a lease deed, if the court finds it's a license, then court can definitely hold that. There have been cases where that has been done. So why can't we hold that this is in the nature of a will?
What I'm asking.
No, you are asking for more, but he has convinced us nothing more can be.
Need not. What I have said.
Yes.
Safeguard the time of the court. Kindly adjourn this matter. Let me go back and file an application. Need not. If you not see hold today, there is a will. I will go back.
As the characteristics of a will is different from it is a will. We know how to couch our judgment. That we know. So that it does not give any benefit, undue benefit to anyone. It has the characteristics of a will if we feel that.
That will do. Today that became an will. Previously it was a settlement according to us.
That does not save limitation for you also, as Mr. Rai.
I need not open my mouth to that.
No, the Supreme Court judgment, Mr. Rai is right on that.
Kindly read once again that judgment.
Not that.
That is in the context of a suspicious circumstances. That is one of the ground.
And right to sue also.
And not today, my lord, is
Question of
not
right to sue. We
decided
won't give
that.
any further clue to you. You need not get any clue. So on what do you want to come prepared, Mr. Rai? Everything is over.
No,
Show us the document and let us interpret.
No, my lord, your lordship will kindly allow me to come back, my lord. I may satisfy your lordship, my lord, all on a sudden that it's not a will also.
Yes, definitely.
That also may be there.
That's very well heard in part for further hearing on February 5th, opening day. February 5, 2020.
Opening day. Right.
No, there are 2 days, four Consecutive holidays after, before that.
And I was
Lord,
thinking
instead
of
of fifth, Lord, can it be sixth?
Sixth, very well. Sixth, we have many other matters. Everybody is wanting. Why fifth? What is the what is the difficulty in fifth?
Lord, there'll be some difficulty.
আবার কুম্ভ
কুম্ভ না
আচ্ছা sixth তাহলে করে sixth returnable on sixth.
Grateful.
Thank you. Sorry.
Number 23. 23, I'm for the appellant. I'm praying for a week's time for filing the paper book.
It's time for filing paper book.
Liable to respond number 1 and 2.
Why for week's time? Why aren't you prepared today? We directed you to file paper books.
Paper book's not ready, my lord.
It has to be photocopied only from your copy. Definitely, we won't grant you a week. We'll dismiss the appeal for default. There was specific direction given to you yesterday. How much time does it take to photocopy a Xerox copy, photocopy a paper book? No, we are not granting time. Have it Xeroxed right now. We'll take it up at 2. Refuse, adjournment is refuse. We are passing it over. Have it photocopied, come back at 2. They have copies, you have copies. We'll hear out the matter. Come back at 2, take out photocopies of all this. Pass over till 2. দুটোর সময় আবার ডাকবেন এটা। Yes.
আর বলার দরকার নেই, এত হয়ে গেল। আগে তো বলবি সকালে মিলছে তুমি পরে একটা বলবি।
Application is there.
If they don't, then we'll draw adverse inference against them.
Item number 24.
May it please your lordship. My lord, lordship will recall, my lord. Lordship was pleased to, my lord, admit the appeal and condone the delay. My lord, short point.
Yes.
My lord, contract, my lord, contains a termination clause. My lord, I had, my lord, written a letter to them that there is a possibility that their position might be made redundant and therefore they may look for other opportunities. It is at, my lord, this juncture that, my lord, the respondent goes, my lord, files a suit and, my lord, obtains an injunction behind my back. My lord, we, my lord, endeavor for, my lord, a period of 6-7 months to try and get this vacated. My lord, unfortunately, my lord, whatever reasons, my lord, the injunction, my lord, continues. And, my lord, the matter is returnable. My lord, 5th of February. My lord, short point, my lord, from the employment contract, let me just show you the clause, which, my lord, says that with a 3-month notice, I can terminate him. And, my lord, I have to pay him, my lord, whatever the compensation is for that 3 months. But today, my lord, lordship will recall, my lord, Mr. Chaudhary was leading me on the last occasion. We had, my lord, said that I am, my lord, happy here and now to give him the notice and, my lord, give him 3 months of pay, my lord, and the matter comes to a rest. That is, my lord, all. May I only, my lord, trouble you by showing you the termination clause, which is, my lord, contained in the employment contract. It's barred by the, my lord, Mr. Chaudhary is leading me.
He can put on. What point involved is, my lord, whether injunction can be passed in a contract of personal service. My lord, the contract has a termination clause. It is determinable by nature. So hit under section 14, both grounds of section 14. My lord, earlier 14 had, my lord, personal service. It was clarified here on both grounds that it is determinable only with 3 months notice. And, my lord, the impugned letter, my lord, which was the subject matter of challenge, that is only saying that you come and meet us. We will see whether there is any scope of your, if your any other scope elsewhere. Otherwise, your employment will be terminated.
Let us see the notice first, Mr.
Let page 41 of the stay petition in item 25.
Item 22 is the FMA number.
FMA 21. 22, sorry, 22.
পেয়ে গেছি চিঠিটা পেয়ে গেছি একটাতেই অত পাতা আছে
But it has, it's a Xerox of a scan copy. We have also got typed copy for your lordship.
We can follow this, no difficulty.
What are the typed copy? The second document is a typed copy and the first document is the.
Sorry. Yes. But this is very ominous. In the absence of any alternative roles, your employment will terminate by reason of redundancy. Is any timeline given? 30-day consultation period.
No, no timeline was given here. This is, well, to be very frank, this is not the termination notice that was conceived of. We were really, well, we had called, this notice has been given to many such employees. We were trying to figure out an alternative role. In case we were unable to, then, my lord, we would go for termination, and for termination, Lordship will find at page 26. I have to give him a notice for 3 months. Under clause 6, I'm sorry, madam.
Yes, yes.
6.1. Your employment is subject to the terms of this agreement for an indefinite period unless and until terminated by 3 months written notice on either side or otherwise as provided in this. So, my lord, under section 14D, it is determinable by nature. So, no question of any injunction. And on top of it, my lord, it's a contract for personal employment. Personal service.
Yes, yes. So what was an injunction was granted?
Yes.
Restraining you from taking steps on the basis of this?
Yes.
29 January.
My lord, Lordship will see the order
See
under.
the order, yes. Why two appeals?
My lord, one was the initial order passed, and then, my lord, it was being continued.
Oh, right.
Lordship would recall, my lord, Lordship condoned the delay in the other matter.
Other matter. No.
In fact, my lord, this appeal is from the last order.
Yes, this is from the last, so we need to look at the other. So the order also says potential threats of termination.
Yes.
Hmm.
And, my lord, it is saying violation of the termination clause in agreement at page 26, my lord.
Mr. Chaudhary, why couldn't you have proceeded with a fresh termination notice and just
No, my lord,
have them
kindly
terminate?
see the order, my lord. My lord, they are the bank management is very, my lord, so far as not being guilty of contempt, they are very particular. Kindly see the ordering portion. Defendants are hereby restrained from giving effect to the letter dated 29 till so and so, and this has been continued. Because, my lord, we had said that you attend. If we find, then we will issue a termination. So, if the condition precedent was not complied, my lord, there was scope of saying, my lord, effectively, my lord, I think they understood correctly, my lord. It would have been an overreach of the court order.
All right. So,
and my lord, kindly see, they are saying it's in violation of the terms of the clause of the agreement. My lord, the only violation can be, my lord, firstly, it is not a termination, it is 3 months notice had to be given. That can be the only violation. But, my lord, in such cases, my lord, lordships have consistently held that all that you are entitled to is not injunction but 3 months damage. And, my lord, I am saying I'll pay here and now 3 months, my lord.
Salary.
That is all.
Yes, Mr. Maninder. Contract for personal service, determinable by nature.
But your lordship has considered 76 Supreme Court and delivered a judgment.
What have I done there? Something wrong must have been done.
If it comes within the 3 exception clauses, then it can be enforced by reason of the amendment to the Specific Relief Act.
But this is squarely covered. Why do you say that? Specifically factored in.
Please come to your lordship's judgment.
Single, sitting singly.
This is the bishop judgment which I had. Church of North India. I also have that
Oh.
judgment, but I think that is, my lord, the old unamended section 14, where lordship para 77. I think.
Please come to paragraph 76, paragraph 75 at page 33.
copy lagro.
But the three statutes were taken into consideration: the 1877 Act, 63 Act, and the 2018 Amendment. Please come to paragraph 75 at page 33 straightway.
Yes.
Keeping in view the deletion of the illustrations to section 14 in the 1963 Act, the expression quote unquote personal service used in subsequent judgments cannot be taken in an unfettered sense, but has to be read down and moderated by the expressions master and servant relationship and contracts of personal nature. The language of the parent provision gains more importance in the backdrop of absence of the illustrations in questions. The key terms in section 14(1)(b) of the 1963 Act before the 2018 Amendment in the present context are runs into such minute or numerous details so dependent on the personal qualifications or volition of the parties, and or otherwise from its nature is such that the court cannot enforce specific performance of its material terms. As such, question 1 as formulated above can be answered thus. A declaratory suit in respect of a contract of personal service is barred under section 14(1)(b) of the 1963 Act only if it satisfies one or more of the conditions specified in section 14(1)(b) of the said Act and not otherwise.
And this is also a contract which is very nature, by its very nature, determinable.
That's one aspect of it. Please come to page 22 of the report now, of the judgment now.
Of the
Every contract is determinable. Every contract. Every agreement, every contract is determinable. Even not government service is a contract, except not the employees enjoy a status.
Service contracts, yes.
Every
Every
service is contract.
But there may be other contracts, suppose specific performance of a agreement for sale. So that is not
a lease agreement, a contract
Yes.
for lease, a rent agreement, a tenancy
lease
agreement.
maybe, but agreement for sale, that may not be determinable by its very nature.
Now, please come to page 22. Now, this was also taken into consideration. Paragraph 47.
Yes.
This rationale, not the rationale was not whether a contract of personal service is enforceable or not. The rationale, obviously, according to Justice Bhagwati, could have application only where the contract of employment was a contract of personal service involving personal relations. It could have little relevance to conditions of employment in modern large-scale industry and enterprise or statutory bodies, or where there is professional management of impersonal nature. But where I am employed by the bank, it does not become a contract of personal service. And not this judgment has taken not care, not in-depth care of not the interplay of the provisions of 1877 Act, the 1963 Act as section 14(1) stood at that point of time with the 2018 amendment.
So this is on personal service. Determinable. Cannot just say that every contract then would be determinable.
Every contract is determinable.
Then every contract is barred.
Please,
That's
Please come to once in
a contract which in its nature is determinable.
It's by its nature.
Service contract is by its nature
It
determinable.
says you will continue, the appointment letter says you will continue till the age of 60 years.
Yes.
Otherwise, if you are not prematurely terminated. So it is a contract terminable on 60 years of attainment of 60 years of age. A premature termination is not determinable as such. Parties have entered into a contract that this service would continue up to the age of 60 years. It's not a contract for a period of 5 years which becomes determinable on expiry of time. Say a project, it is determinable on conclusion of a project. Or say a service which is a contract which is governed by 10 years. You are engaged for 5 years. It becomes determinable on expiry of 5 years. So it's a contract which is governed by, stipulated by time, or a contract which is stipulated by a particular work.
But premature termination is.
So that is probably a determinable.
But no.
Contract which by its very nature is determinable.
Yes, let us come to that clause, the page 26 of the application. In the other FMA 181.
Yeah.
Clause 6.1.
Yeah. Please come to 6.2.
Yes, but that is circumscribed by 6.1 also.
Your employment is subject to the terms of this agreement for an indefinite period, unless and until terminated by 3 months, written notice on either side, or otherwise as provided in this agreement. You will retire from the services of the bank on reaching the age of 60.
That is by default if this is not done.
So
but it's terminable by 3 months notice.
Normally it's 60 years.
60 years
is the condition of employment. Now, the contract by its very nature is not terminable on expiry of a certain eventuality. It's not a contract specified by a particular job. It is not a contract specified by a particular time. The contract would ordinarily run till the employee attains the age of 60 years. Now the court below is considering whether this is a just action and a declaration is being sought for.
And what about the notice, the suit being premature, the injunction, because the impugned order, in the impugned order, the court itself says, Mr. Mujumdar, that prospectively or something like that, the language used, potentially that is used.
Prima facie, it appears to me, page 14.
Please come to the ordering portion, the last page of the impugned order. We have the memo with us. Yes, prima facie, it appears to me that the letter has potential threats of termination. So it's not a termination letter.
Unless you find a different employment in the same bank, you will be terminated.
Work will be redundant.
You will be rendered redundant and you will be terminated. So the contract for which I had been entered into is being terminated.
What is the ground on which you have challenged this notice? Without not with 3 months notice or what?
No, I challenge this on the ground that this is really unconscionable, number one, and number two is you are terminating my service on the ground of redundancy without any notice whatsoever. I have to seek another employment within some sector or parameter.
But they have a right with a notice, 3 months notice.
That's there. Of course,
so if they are agreeable to give you the salary for 3 months.
That is why we have compensatory damages. Now, today the question is whether it is a contract which is terminable on expiry of a term or a contract terminable by a...
3 questions, personal nature,
project.
determinable, both of which you have answered. And third is this, that whether this is you are entitled to an injunction, because at any point of time they can give 3 months notice and have it. By virtue of this injunction order, they have been prevented from issuing a further notice also. 3 months notice now.
But whether this can be done, this is the only ground on which they proceeded was you are redundant. They are not terminating my service on invocation of clause 6.1.
So then we can make it clear, Mr. Mujumdar, that
please don't. Please don't make them wiser. After all, it's
that,
employment.
that does not prevent them from issuing a fresh,
in that event, not
fresh valid notice of termination
that-
under clause
in
6.1.
that event, not I may not be in a position to challenge that termination.
Fresh suit.
once again. Not if
Or
that does not prevent
amendment or amendment.
Not one has to justify. Not it one fine morning. I cannot say that.
No, but by
filing
virtue of
notice
this injunction, you are enjoying something which is beyond
I'm
the scope of
working.
the
I'm working. I'm earning my livelihood against my service rendered.
beyond the scope of the suit, Mr.
I'm rendering my service and they're paying me my salary against services rendered.
Every termination takes away livelihood. Then there will be no termination.
That's why there are protective clauses before termination is
Absolutely.
effected.
6.1.
6.1 is compensatory for the purpose of damages.
No, they can as of today they can give a notice 3 months notice and without giving any reason they can terminate you as per clause 6.1.
That has fallen for consideration time and again before the honorable courts, and your lordships have been pleased to repeatedly lay down that such a provision in a contract is unconscionable.
Anyway, very well. Reply, Mr. Choudhury. Oh, sorry. We'll take the replay after this is.
Can it be tomorrow, my lord? I am on legs, my lord. At
Yes, yes. Not tomorrow, then next. Tomorrow we are sitting singly. So next Wednesday is the next weekday available.
But I understand the matter is on 5th on the
Fifth, another.
in the lower court.
This matter. Can you come back later? I mean.
But can I come at 3 o'clock?
Yes. Come back at 3 o'clock. This matter will be taken up at 3 o'clock next.
Deeply obliged.
3টের সময় আবার যাবে।
Lordship, I am for the plaintiff appeal.
Yeah, why couldn't you file paper books within a day?
There is a misunderstanding between me and my juniors. They did not communicate me that Lordships inquired of the Xerox copy of the paper book. That was the problem.
So now it has been prepared. Very good.
And for the respondent number 3B.
Yes.
The direction that at the time of the hearing of this appeal, my lord,
Yes.
statement of accounts.
Yes, what about that statement of account?
No, Lordship, there was no direction of Lordships to provide the statement of accounts. Because Lordships, they don't have any locus standi to file their application. If I succeed, they would automatically go on.
My lord, last order, my lord.
No,
The statement of accounts will come if they succeed.
Which date? Which order of which date?
In December 2024. This is your lordship's order. Paragraph number 2. We make it clear that we share the accounts were directed to
I think December or November.
Lordship, paragraph number 2, we make it clear that the said accounts which were directed.
Yeah.
Lordships got?
Yes. Accounts which are directed, if so directed by the court.
At any point of time.
At any point of time.
We have not directed.
Or at the final hearing of the appeal. So, my lord, at the final hearing.
No. If so directed by the court, that is qualified by directed by the court at any point of time or during at any point of time during pendency of the appeal or at final hearing. So we have not directed anything as yet. If we feel necessary, we will direct. What is the appeal against?
Lordship, appeal against the judgment and decree of the partition suit. Lordship,
Final degree or preliminary degree?
Lordship, dismissal. Partition suit
Very
were
good.
dismissed on the ground that sister would be a necessary party.
Only on that ground.
Only on that now.
Why do you say sister is not a necessary party?
Lordship, the first suit was filed in the year 2004.
All right.
And Lordship, that suit was dismissed on the ground that sister would be a necessary party, and against that order of dismissal, we filed an appeal before the Honorable High Court and Calcutta, and Lordship kindly come to the page number 30 of my supplementary paperwork. The order of the Honorable Justice Banerjee and Honorable Justice Dr. Mrinal Kanti Choudhury as then were. Page 30 of my supplementary paperwork.
Yes.
Lordship, fourth para from the bottom. We feel the subject document, although stated in the earlier part, daughter would be excluded, the last part would be document would say otherwise. This issue should be considered in the presence of the sister as well. We abundantly make it clear we have not decided as to the right of the sister to claim any share of the father's property. Then the appeal succeeds and allowed, the judgment and court of the order of the court below is set aside. Then Lordship, it was remanded back, and the last.
No, the sister was directed to be added.
Lordship, she was added.
She was added.
Lordship.
Then
Lordship, the present added respondent number 3A and 3B, they are the daughter and son of the sister. And Lordship, this is a genealogical table. Kindly. Lordship, Radha Mohan Ghosh was the father of the parties, and he made a deed of settlement. Lordship, this deed of settlement is the only key to enter into the appeal. Lordship, the partition suit was filed on the basis of this deed of settlement. This deed of settlement is a registered one, and deed of settlement has not been challenged at any time.
So how can a partition suit lie if there was a deed of settlement distributing the shares? It was a registered deed.
Lordship.
Then no further partition is required. How can the partition suit be maintainable then?
But Lordship, that partition was not possible between the brothers, for which the appellant filed the partition suit.
But partition suit, if there's a family
Lordship,
settlement.
I understand, Lordship.
So you could have filed a suit for implementation of that. So you say this partition suit is basically for implementation. You seek a partition in terms of the family settlement.
Only, Lordship, nothing else. Only on the basis of the deed of settlement.
Let us see that is not a ground. That is not a ground of dismissal. You say the dismissal of the suit was for.
Lordship, now, when the second suit was filed, against
Not second suit.
second suit after remand.
After remand,
After remand.
same suit, yes.
Second suit was filed, and second
How
suit
can a
was
second suit be filed? The remand means the same suit continues.
continuation of the same.
Is after remand what happened?
After remand, Lordship, this suit was also dismissed, and what the learned judge had done, he has included all the properties which are not the subject matter of the deed of settlement.
No, let us see why it has been dismissed. Let us see the imputed judgment.
Lordship, kindly come to it starts from page 123 of the main paper.
We'll continue this matter up to 3 p.m. We have another fixed matter. So as far as we can proceed, we will hear. Yeah.
Your Lordship will find my page 144 of the Malad judgment. 144.
123, what is that?
123 starts of the judgment, 123
starts, Lordship.
Page 144, you'll see page 143 or page 144, last paragraph. Your Lordship, kindly have a look.
No, before that it has been held the suit is not maintainable. Acha, cool. Yes, please place your case.
Lordship, first come page 138
Yes.
of my paper.
Yes.
Lordship, starts from last 2 lines. Let me now devolve upon the dispute as to the share of the party as raised by the contesting parties in their respective shares.
Pleadings.
Pleadings. Lordship, then kind to page 141. 141, 9 from the bottom. Taking into the account the above mentioned plot, this court has got no other alternative but to hold that the instant suit for partition is defective as the entire joint property is not brought on the record. But Lordship, this is beyond the plaint. I did not pray for that. I only prayed before the learned court below that the partition should be made only on the basis of the deed of settlement made by my father. Lordship, then how the learned court below can pass this order?
So but it's settled that if it's a partition suit, all the joint properties have to be brought in the hodgepodge. Now you have filed not only a suit, for the suit is not only for implementation of the family. Let us see the prayer in the plaint.
Lordship, page
Decree, it's a regular partition suit. So if you file a regular partition suit, it cannot be only on the, suppose the family settlement deals with a part of the property. There are other joint properties also. Then if you file a partition suit, maybe regarding the joint family settlement, you can say that that portion of the property has been already settled, give us shares in respect of that. But regarding the other joint property, that has to be brought in the hodgepodge. It's a regular partition suit. You are saying it's well settled that in a partition suit, all the joint properties of the parties, otherwise it's bad for non-joiner of all the properties.
That is
partial partition it would be.
Lordship, but my prayer was, Lordship, only to implement the deed of settlement.
That was not your prayer. Your prayer was for a decree in preliminary form of partition in the suit by meets and bound. So you seek a regular partition.
Lordship, by meets and bound to the extent of the plaintiff's 1/3 share in accordance with the deed of settlement.
That is not spelled out in the plaint, in the relief. Maybe that is the basis, but if that family settlement deed did not encompass all the joint properties,
Lordship,
then all have to be brought in. Again, another remand. It has been dismissed outright, but we subject to hearing the other side, we shall hold that if that is the view of the court, then an opportunity ought to be given to you to amend the plaint and have the suit. I mean, otherwise there will be another partition suit unnecessary. So let us dispose of the appeal and direct that. Why you keep
Plot number 450 of oblique mallet
158. Yes.
That has been not been taken into consideration because that is a joint property. Well, UCO Bank is tenant in that property.
Only that proper plot has to be brought in. Yes.
Initial suit was for the general partition. All the properties has been not included. Now, my lord, in the second, after remand, my lord, they had been
Oh,
changed.
in the previous suit, this 450 by 1258 was also included.
No, Lordship, no.
Only
Never included.
Never included.
Never included.
450 has not been included.
Now it will be.
There are four drug number 4257. My lord, kindly come to the page 6 of the supplementary, my lord.
No, what was the finding of the court regarding the family settlement? Family settlement was upheld by the court. Because at page 138 we find that the court holds that I therefore do not find any shortcomings or any illegality. Therefore, regarding if the original owner, the deed of family settlement was executed by the original owner, he was the exclusive owner. So it's within his rights, the original owner's rights, to demarcate a particular part of the property and settle that between his heirs or whoever. So regarding the portion of the property, those 4 plots, which is covered by the family settlement, the court has to go by the family settlement and give that partition only. Regarding the other plot, left out plot, court will declare shares and then.
Previously, they may not file the suit for the entire property.
Again, you are saying entire property, but then you are saying 450 was not included.
Property was never included.
May not kindly come to the page 6, my lord.
Your argument is contradictory. You are yourself saying that 450 was not included.
450 has not been included.
Then how could it be entire property?
Entire property only four plots.
No, entire property.
Entire, what do you mean by entire?
The property which has been claimed by them, 4257.
No, what do you mean by exactly by entire?
Entire, my lord, the existing property, my lord, 450 is not relevant at this purpose.
Why?
Because that is now a road, my lord, for public utilization.
That has to be proved in the suit, but if it is joint property.
Yes. All the plots which are relevant for the partitions, they had been given, and the area is very, very big, and very small portions has been made in the deed of settlement. May not kindly come to the page 6.
Page 6?
Schedule.
Yes.
Plot number 4257, Bastu measuring 739 sataks out of 850 sataks. With 1-story building with covered area about 550 square feet, which is tenanted to UCO Bank, 1 subroom adjacent to the UCO Bank premises. Calcutta. Plot number 4254, measuring out 248 sataks. Plot number 4259, one measuring about 170 sataks. Plot number 4260, Bastu measuring 340 sataks with a 2-story building standing there. That is their, my lord, submissions. 340 square feet, that is, my lord, about 10 bigas.
What is your submission?
My submissions, my lord, it is a general partition. It is
Yes,
a general partition.
that is what we are saying also.
Yes.
If it's a general partition, all the joint properties have to be brought into the hotspot.
That is to be.
So 450 by 1250 will be brought.
They had been changed the city, and by giving very small portions, they have been asking for partitions, but they have been taking the rents from the entire property.
That we will give you leave to. We are disposing of the appeal. You prefer that share in the rent. In the code below, you don't have a counterclaim in the code below for share in rent.
Counterclaim
For rent.
Yes.
You have filed.
I have filed.
What was the decision of the court on that?
No decision has yet been passed.
That counterclaim is pending. That will be kept pending.
Counterclaim.
That is already there. You have that counterclaim. We will remand this suit by upholding whatever has been held by the trial court. Page 144, the court says that during discussion, as made in the preceding issues, it has been held that share of Ashok Kumar Ghosh as per settlement deed shall devolve on his brothers, plaintiff and defendant numbers 1 and 2, and also upon sister equally as he admittedly died being unmarried. Defendant numbers 3A and B, U, is held to be entitled to 1/16th share of these 4 suit plots. So 4 suit plots have already been allocated by the court in terms of the family settlement. We are not disturbing that. We are saying since the court held that plot 450 of 1258 is left out, an opportunity will be given to them to amend the, or we will give a direction on them to amend the plaint and include that plot. and the suit will be remanded only on that point for the court to consider what is the whether partition can be granted. If granted, how.
Now, my lord, one
We'll uphold this first portion of the.
yes, but when the schedule has been changed, let the consideration made according to the deed of settlement, not the other joint properties, my lord. The joint initially they had been filed the suit for total property.
Mr. Chatterjee, the family deed of family settlement was never acted upon. That is their case. Court accepts that and says that no, I pass a decree in terms of the family settlement. If the family settlement was acted upon and you are in occupation of your respective shares, there would not be any reason for them to file a suit by spending money. Obviously, because the family settlement was not acted upon, this suit has been filed. Although it was a registered deed of family settlement and it is binding on the party. Therefore, regarding the plots, 4 plots covered by that family settlement, we cannot go behind the family settlement. Court has directed the 4 plots to be allocated in terms of the family settlement.
But there was such dispute, my lord. Kindly see the schedule.
We have seen the schedule. What should we compare it with?
First schedule and second schedule is something different.
This is the first schedule, page 6. Page 6 is the first.
First schedule.
When did they amend the plain? The same suit is continuing.
They had been amended by themselves.
Oh, the previous suit. This is the
Previous suit.
where is the previous schedule?
My lord, kindly compare, my lord, supplementary paper book, page 6
6
and
and
7 to my lord, paper book, my lord, first paper book that has been, my lord, submitted before,
Yes,
my lord,
yes.
page 7. You know,
Page?
kindly compare, page 7.
7.
6 and 7 from, my lord,
No,
supplementary
in the
paper book.
old paper book, which page?
Page
Old
7.
page
Lord.
7.
And supplementary paper book, page 6 and 7.
No, those are identical.
Identical,
No.
yes.
What is the difference?
Difference is this 0.739 শতাংশ।
এখানে এটাও লেখা আছে।
4257 Bastu measuring about 0.739 শতাংশ।
0.739 is generally shotaks are put in as that.
shatak.
That means 739 shotaks.
One-
Decimal, when we say decimal, it's usually
Shatak is something different, madam. 1 shatak means
shatak is not decimal.
1 shatak means 435 square
Achha,
foot.
you say so 0.73.
0.739 shatak. That is changed. The initial it was 1,000 times bigger.
All right. The
And
decimal point.
latter one very small. And the Miller deed also, kindly see the deed,
Yes.
175 page.
That same thing is regarding 0.314 shotaks in 4, item 4 also.
Yes,
And also 170. Point has been given everywhere.
everywhere point.
Except 2. Except item 2. Decimal point has been incorporated everywhere. And the original deed of family settlement did not contain those decimal points.
That is the decimal point. Kindly come to the page 175 of the original paper book, Miller. That number 4257 Miller.
Points are there.
8.85 shataks.
That means so much decimals it comes to.
So decimal Miller something.
Point means 0.375. The original family deed of family settlement.
Is 0.854 shataks.
Point is there.
Yes.
And the current schedule also contains those decimal points.
Yes.
So this is the current schedule is in consonance with that family.
Not on the original schedule, Miller.
Original schedule, forget that suit has been disposed of. The High Court has set aside that, rather remanded that.
Yes. 0.8.
When did the amendment take place? The same suit was remanded by the High Court.
Lordship.
Only Miller addition.
There is no new suit here.
Is not the new suit.
This must be a typographical error in the
Must be typographical. Must be typographical.
Mr. Chatterjee, we'll go by the schedule. Whatever is there in the original schedule,
Yes.
we'll go by that. And the decree has been passed on the original schedule only.
Yes.
Decree has been passed not on this copy of this plain.
Yes.
This paper book is erroneous.
Their dispute, Miller, they have been submitting that based on the deed.
Yes, yes. But no, let us see the schedule of the impugned decree. That will clarify everything.
Page 168.
Yes. No, 140, 147, what is that? That is the decree, impugned decree. Oh, decimal is not there. Acha.
That is the jagdaldies they have been making. The entire property has been, it is a general partitions, they have been.
Then it would be beyond the property of the original owner.
Major of the property will remain with the original owner. When the general partition has been asked, all the properties to be to come into the record, and my lord, within the property, my lord, there is a band. Monthly, my lord, 40,000 rupees is, my lord, collecting by the respondent number 1 and 2 and the appellant. They are not paying anything else to the sister. That is the application, my lord. And my lord, from the pawn monthly, my lord, 2 lakhs rupees is earning. They are not being given. There are several tenants.
কত ভাড়া কত এখন 9,000 টাকা তো আগে ছিল
I have got the, my lord, RTI, I have applied for.
But you have not filed any appeal against this degree.
No, my lord, I have filed the appropriate applications, my lord. And in that case, my lord, your lordship.
You have not challenged this degree, partition degree. They have challenged the degree. You have not preferred any appeal against the degree. So then how are you aggrieved? How can you be said to be aggrieved? If you have not preferred any appeal, you cannot be hard to say about that.
But, my lord,
There is no appeal at your behest. You are not aggrieved even.
But, my lord, from the evidence, it appears that they are getting the money from all sources. They have been filed their appeal.
No, no, money, all sources, your counterclaim is pending. That will be taken care of. We are not deciding the counterclaim.
We have not been added that. We have added that the deed is void. It has not been acted upon and it cannot be acted upon.
Have you made a counterclaim for this for your share in the?
See, at any time
Yes,
they did not challenge.
So that will be decided.
1/4 share I have applied for.
This point, the decimal point thing, you are raising for the first time now at the hearing of the appeal. You have never challenged the, never preferred any appeal.
They have changed it by themselves.
So you did not prefer a challenge. The trial court has granted a degree on their change.
I challenge in the counterclaim that
The decree stands as of today. The partition degree stands. Rather, the dismissal stands where there is a specific finding.
The deed is been reviewed, my lord. I have stated in the counterclaim that it cannot be acted upon because it is a very small plot of lands has been given that cannot be participated. However, my lord, the learned court below, my lord, decided on the basis of their deed event and that the sister will get 116 shares.
Lordship, without challenging the validity of the deed of settlement, how they can raise this type of points at?
No, they're relying on the deed of settlement. Mr. Chatterjee is saying that deed of settlement mentions point.
Lordship.
Whereas you have enlarged the property by omitting the decimal points. He is relying on the deed of settlement. If you are also relying on the deed of settlement, then how can the decree be passed on 739 shatak instead of 0.739 shatak? You see the decree, impugned decree. In the impugned decree, no decimal point is there. Whereas in the family settlement deed, there are decimal points. Family 174 is the schedule of this family settlement, isn't it?
That is page 175.
Part 1, part 2, where are the parts mentioned? Page 175 says part 1 being part of the aforesaid schedule and according to part 1 is allotted. Where are the parts?
175 of the page.
Part 2 is, my lord, starting from 161, page 161.
Oh. (161). There is only one family deed of family settlement.
Not see only one.
So where are the parts mentioned? The part of it, half of it is in English. 174, 174, or this is a translation?
It is a translated copy.
Let us see the original. Let us see the original.
Lordship, the
Page
original,
168.
168 and Lordship.
Schedule.
Part one is page
168.
165.
Part 1 is 165.
That is the Bengali version, Lordship.
Yes.
Ek number
We will let us see the Bengali.
Starts from page 161.
Right.
Portion is 168.
And this also says that Nijera partition Korea loibe. So you have a point there also that it required further implementation.
All point, my lord. 8.856 shatak, 0.248 shatak, 65.9, 1.17 shatak.
But this is a new point you are raising for the first time. In your written statement, did you raise this point?
I have denied their statement, my lord.
Denial won't do. Have you taken this point that the schedule, have you challenged the schedule specifically?
Challenge entire, my lord, the deed.
Entire deed cannot be challenged. Entire deed your challenge has been turned down.
Entire deed, my lord, only because that.
No, this specific case has not been made out before any forum. Taposhil Sampati, let us see. So the property, the description of the property, how do you define this schedule? The deed of family settlement does not specify so many shatoks and all. Let us come to page 165. Ek number dafa is lot 1. That is such and such. Topshil ukto jinno bosot badi ditwaler puraton dukhani ghor. But here it is something else. Anyway, let us, Taposhil Sampati is defined. That includes Kotiar number Shodok such and such Shotok. .856 Shotok. We do not find that the schedule of the family settlement deed is tallying with the schedule of the plaintiff. We cannot correlate even. Mr. Chatterjee, would you be satisfied if we relegate the matter back to the court below and direct it to reconsider and grant partition in respect of the property covered by the family settlement deed in terms of the family settlement deed as per the schedule in the family settlement deed? And regarding the other joint property which has been left out, we'll direct them to incorporate in the plaint.
Lordship.
Because they are also seeking implementation of this family settlement only. Whatever is there in the schedule, we'll direct the trial court to, we'll remand the matter to the trial court and direct it to grant partition in terms of family settlement, deed of settlement, in as much as the property covered by this family settlement is concerned and the rest schedule is concerned, and the rest of the property that independently partition will be given.
Only one property, only 450 or 152 each.
Shares to be declared.
No, but we
according to the mirror.
shares have, but this Taposhil Sampati we cannot correlate your plain schedule with this. How can you tally this with that? It is completely different.
Yes.
Well, it differs.
It entirely differs. It's something else. You just see the family settlement deed. Then your schedule becomes bad. Mr. Chatterjee is right on that. Your schedule mentions something of your imagination. Plot number 4257, 4258, 59, and 60. But here, what plot numbers are given? Let us see. Yes, 4257 is there.
4259, 4258 also there.
Also there.
Well, 4260 also there.
So let us see whether the areas tally. 4257, 739 he has mentioned. 0.739, let us imagine.
0.739.
So
4258, my lord. 0.248. Here, my lord, 0.248. Here, my lord, also 248.
No, 0.248.
No, no, 248 আছে, এখানে 248 আছে।
Where they are giving
No, regarding 4257, that is 856.
856.
856 Shataks. That
But-
is a very big.
No, he has
Palabara.
claimed 739 out of 856 in the plaint.
Lordship. 0.032.
What has the trial court done? Let us see. You have created a confusion. You should have just quoted the schedule of the family settlement, deed of family settlement, and said that let it be done in terms of the family settlement. Family settlement does not give you any particular area. It only mentions the house and some part of the premises there.
But they are presuming that they are the 1/3 shareholder and selling the property. Several properties has
Those
been
are,
sold.
I mean,
And you know, that was included in the partition suit. Several properties they have been sold. They have been taken along the plaintiff as well as the appellant. My lord.
what was your challenge to the deed of family settlement? Let us see.
That is the
Oh,
625.
His counter place starts at page 19 of the Malad paper.
Yes. And I
Yes.
say that I am the 1/4 shareholder, and I challenge that this counterclaim that the deed has not been acted upon. It cannot be acted upon
why?
because the small portions of the land, the house property, my lord, the Vastu 4060 is being given as
No, this will only be if you direct it to be remanded. Here is suit has been dismissed. If you remand it, we can direct the trial court to proceed on the basis of this deed of settlement, and only the shares will be declared by the preliminary degree. Then at the time of partition, you can always take the point that royalty money be given instead of the shares.
No, my lord, in the meantime, my lord, they are only, my lord, by force, my lord, collecting the money.
But if the suit goes back on remand, you can approach the remand court. Appeal court is no longer in season of the matter. We become functus officio once we dispose of
So,
the
my
appeal.
lord, at this time, my lord, let the
This appeal is already pending since when? For 4 years,
let
5
the,
years.
my lord, from they should be rested to collect the rent.
After disposing of the appeal, can we do that? We are functus officio.
So, my lord, in that case, my lord, they will take, I will be deprived. They had been initially deprived.
Are you enjoying any injunction order in this court?
No injunction, but the order is this, that they should have to produce the statement of accounts.
That you can pay before the court bill also.
So, my lord, in the meantime, my lord, they have been, they have to
Very good.
taken the money.
Let them do.
I have nothing else, and I will fight for
You can always ask for the accounts from the date of inception of the suit. Need we teach you that, Mr. Chatterjee?
So, my lord, kindly protect me, my lord, anyhow.
What sort of protection? We have to physically go to the field and protect you then.
They have to, they are collecting the money as a landlords. I will apply then liberty to be given, my lord.
Liberty is always there. Who prevents you?
So that should be noted, my lord. I have the liberty. I will apply to the bank to get my shares. That is my application, my lord. It's about 1 crore of rupees they had been collected as a rent from only Eco Bank, you know. And
Perhaps Malad in counter claim there is Malad no averment to such Malad collecting of rent. No averment is there.
You're saying something which
Subject
is
to
beyond
collection.
you.
Counter claim
Page 25, my lord, of my application, my lord.
In fact, the trial court has not gone by that description of the decimals. Trial court has In fact, this is a splendid judgment. Page 138 to 140, the trial court takes the trouble of going into the entire shares and gives it and holds that those are they are entitled, and your case is disbelieved that you said that subsequently they were.
Has not been.
Yes, the defendant number 3A and B similarly will your it has been disbelieved. You challenge the deed of settlement. That has been turned down. Page 138, court says specifically, moreover, from deed of settlement, it is clear that the settlor had made his intention clear, etc. I therefore do not find any shortcomings or illegality in the deed of settlement, and therefore differ from the contention of learned advocate for the defendant numbers 3A and B, who has challenged the validity of the deed. So validity of the deed was upheld, and trial court went into the question at the outset of my discussion, Adjournment to look, the shares were delineated in terms of the family settlement only. But no preliminary degree was passed only because of this defect.
The share has been declared 160, but in respect of the property that has been settled, not the others' property. Others' property is there. That is the major portion. It is a general partition, my lord.
Achha, Mr. Chatterjee, tell us why your learned friend is not correct in saying that he is seeking an implementation of the family settlement deed, right? By which a portion of the property, the owner selected a portion of his property and distributed that between his heirs. And he said partition will be. His partition is in respect of that property only, not regarding the other. So why should it be bad for partial partition? He is seeking an implementation of the family.
Itself says they had not been given the absolute right. They had been appointed as a trustee of the property, very small portions, trustee of the property. But
that has been dealt with by the trial court, and there is no challenge by you.
I have no objection in respect of the property which has been settled to be adjudicated, that has already been adjudicated, and 116 shares have already allotted to me to all portions. But apart from that, the major portion to be, because their original plaint is this, the entire property has
You did not take out any challenge regarding there being any other portion. Defendant number 2, 1 and 2, they took up a challenge.
Yes.
Mr. Dalal's clients took up a challenge that 450 by 1258 also belong to Radha Mohan.
From very beginning, they had been challenged. They had been.
You never took any objection to the property, the only additional property being 450 by 1258. Your only challenge was to the veracity of the family settlement. That was turned down. It was held it's a valid deed. And his client took the objection that there is another plot number 450 by 1258. And for that only it was dismissed that that property was not there. Everything else is, you took no other point. What is your counterclaim? Where is the counterclaim prayer?
There is also
starts from page 19 of the paper book.
No, the prayer.
Page 24.
Declaration that deed of settlement, yes. You challenge the deed of declaration. And you have not. Are you sure the counterclaim has not been disposed of? Because by virtue of holding that.
That has not been, that is pending.
But nothing remains in that. You sought a declaration that the family deed of family settlement is bad. And that has been held to be good. So your declaration A automatically goes.
That is pending, my lord. I also for my information is what. I will also in the record, my lord, that it is paid. Fine.
একটা জিনিস করে দিচ্ছি পেলে হ্যাঁ পুরোপুরি হচ্ছে বলেছি ও কিছু চ্যালেঞ্জই নেয়নি ওটা নিয়েছিল ওই ডিফেন্ড নাম্বার 1 and 2 পেজ 138
for the entire property.
138 clearly এটা করে দিয়েছে বলে দিয়েছে therefore differ from the condition of their condition চ্যালেঞ্জিং দ্য ভ্যালিডিটি আপহোল্ড করেছে ফ্যামিলি সেটেলমেন্টটা করে বলেছে ওটা টার্মসে শেয়ার গুলো এই হচ্ছে বলে পেজ 140 পর্যন্ত ওইটা করে রাখো তারপর শুধু ওই কারণটা এই দিল না ওই প্লটটা আমরা রিমাইন্ড করে এই ফাইন্ডিং গুলো of the appeal, we are directing the learned trial judge to allot the parties' respective shares in the preliminary degree regarding the property covered by the deed of settlement in terms of the deed of settlement, and we direct them to include this other plot 450 by 1258 within the plain schedule within, say, a week after the records go down to the trial court, or a fortnight after that, and the trial court shall, regarding that other plot, independently decide, hear you and decide the shares and grant a preliminary degree.
No, my lord, in that case, my lord, the problem arises that the counterclaim is there. My lord,
Counterclaim will be decided. We are not touching that counterclaim.
The share would be different. In the counterclaim, my lord, I pay that I am entitled to 1/4 share. So
Very well. We'll direct the counterclaim to be decided along with the prior to the hearing of the preliminary degree, prior to the grant of the preliminary degree.
And my lord, the share to be decided.
Unless the shares are decided, how can there be a preliminary degree?
Because the own shares, so far the my lord assess 1/3 is not, my lord, relevant at all.
Very well. Yes. All of you, please take your seats. Unless there is some mistake, just point out. What was the name of the sister? Onima?
Onima Sina.
Onima
Onima Sina.
Sina. The present appeal arises at the behest of the plaintiff in a partition suit, who's by the impugned judgment and degrees of charge. Take your seat.
One thing, my lord. Sister is Onima Sina. Her daughter is Anjana Ghosh. Sister Onima Sina died.
কি বললাম?
Onima Sina.
By the impugned judgment and decree, the said partition suit was decreed on the sole ground that one of the joint properties of the parties pertaining to plot number 450/1258 was left out of the hotspot of the partition suit. Full stop. The plinth of the plaint case was that the original owner of the property, one Radha Mohan Ghosh, within bracket since deceased, bracket closed, left a registered deed of settlement distributing the property among his prospective heirs. Full stop. Next para. In the said deed, the original settler, the settler expressed the intention that the parties to the said that the beneficiaries of the said deed would have the property partitioned by metes and bounds between themselves. Full stop. Subsequently, such partition having not taken place, the suit was filed, in a way to implement the deed of settlement by seeking partition in respect of the property covered by the said deed. Full stop. Next para. At the in the first round of litigation, the suit was dismissed for non-joinder of Srimati Onima Sinha, within bracket since deceased, bracket closed, one of the sisters of the parties, against which an appeal was preferred before this court. Full stop. The appellate court remanded the matter to the trial court and directed the said sister to be impleaded as a party to the suit. Full stop. Subsequently, such impleadment took place, and upon the demise of the said sister, her heirs and legal representatives have been substituted in the suit. Full stop. Next para. Thereafter, the learned trial judge upheld the validity of the deed of settlement, turning down the challenge by defendant stroke respondent numbers 3 within bracket small a and 3 within bracket small b, and proceeded to declare the shares of the parties on the strength of such deed of family settlement. Full stop. However, thereafter, on the objection taken by the defendant numbers 1 and defendant stroke respondent numbers 1 and 2 during the course of argument, that one of the joint properties pertaining to plot number 450/1258 was omitted from the hotspot of the partition suit, the learned trial judge dismissed the suit on such ground. Full stop. Next para. Learned counsel appearing for the respondent numbers 1 and 2 submits that the said respondents do not have any objection in the event the deed of family settlement is given effect to, comma, along with shares being declared in respect of the other joint property comprised of plot number 450 by 1258. Is the next para. Learned counsel appearing for the respondent number 3 within bracket small a, however, objects to such a course of affairs. First up, it is argued by learned counsel that the extent of property shown in the schedule of the plaint is much larger than that contained in the original deed of family settlement, comma, as such, leaving out large portions of the joint property which originally belonged to the first owner Radha Mohan Ghosh. Push up next para, that apart, comma, it is contended that the plaintiff has been depriving the respondent numbers 3 small a and small b by misappropriating the usufructs of the property and collecting the rents from the tenants. First up, it is further submitted that unless the counterclaim of the said defendants is decided, comma, the learned trial judge could not declare the shares of the parties. Full stop, next para. Upon hearing learned counsel for the parties, comma, we find that the learned trial judge elaborately considered the validity of the deed of settlement and came to the finding that the same was a valid document. Pushed up. Thereafter, comma, the learned trial judge painstakingly ascertained the shares of each of the parties in terms of the deed of family settlement, comma, pertaining to the properties covered by the said deed. Pushed up. As such, comma, since none of the parties have preferred any challenge against such allocation of shares, comma, it is beyond the purview of the present appeal to disturb such delineation of shares in terms of the family settlement. Pushed up. Insofar as the objection of the respondent numbers 3 small a and small b regarding the extent of the scheduled property is concerned, comma, such problem can be resolved merely by indicating that the learned trial judge should declare the shares of the parties strictly in terms of the schedule of the deed of family settlement and the shares allocated thereby. Push up next para. Insofar as the omission of plot number 450 by 1258 is concerned, comma, we are of the opinion that the learned trial judge erred in law in dismissing the suit outright despite having otherwise decided the same on merits, comma, on such technical ground, comma, without first granting the plaintiff an opportunity to amend the plaint and omit and incorporate the said left out joint property. Full stop, next para. Hence, comma, we are of the opinion that the matter ought to be remanded to the learned trial judge by retaining the findings regarding the respective shares of the parties in terms of the deed of family settlement and the validity of the same, comma, at the same time directing the plaintiff to incorporate plot number 450 by 1258, upon which the trial court shall adjudicate on hearing parties and declare the shares of the parties independently of the deed of family settlement. Push up next para. Insofar as the objection of the respondent numbers 3 within bracket small a and small b is concerned, comma, we notice that the counterclaim of the said respondents is still pending and should be independently adjudicated by the learned trial judge. Pushed up. In fact, comma, since the defense taken by the respondent numbers 3 small a and small b in their written statement is intertwined and inextricably connected with the relief sought in the counterclaim, comma, In any event, comma, the said issues will fall within the domain of consideration of the learned trial judge at the time of re-adjudicating the suit after remand. Full stop. Next para. Accordingly, FAT 328 of 2020 is allowed on contest partially, comma, thereby directing the learned trial judge to directing the learned trial judge to grant the plaintiff an opportunity of amending its plaint by incorporating plot number 450 by 1258, comma, which has been held by the learned trial judge also to be a joint property of the parties, comma, to bring the same within the hotspot of the partition suit. Full stop. Next para. Upon such amendment being effected, comma, the learned trial judge shall re-adjudicate the suit upon hearing the parties afresh, comma, and thereafter proceed to pass a preliminary decree of partition. Full stop. Such preliminary decree of partition shall be on twofold aspects. Full stop. Insofar as plot number 450 by 1258 is concerned, comma, subject to the parties establishing the joint title of the parties thereto, comma, shares of the parties therein shall be declared independently of the deed of family settlement. Full stop. Next para. However, comma, insofar as the property covered by the deed of family settlement is concerned, comma, the learned trial judge shall pass preliminary decree on such property, comma, declaring the respective shares of the parties in respect of such properties strictly in consonance with the terms of the deed of family settlement and the schedule thereto. Full stop. Next para. Needless to say, comma, while redeciding such issues, comma, the learned trial judge shall also hear the respondent numbers 3 small a and small b on their objections as taken in the written statement and decide the issue accordingly in accordance with law. Full stop. Next para. It is expected that in view of the long pendency of the matter, comma, the learned trial judge shall endeavor to complete the entire exercise till passing of the preliminary decree at the earliest, comma, preferably within 8 months from the date of communication of this order, of this judgment and order to the court below. Full stop. Next para. We, however, make it clear that we do not interfere with the finding of the learned trial judge to the effect that the deed of family settlement executed by Radha Mohan Ghosh, comma, on which the plaintiff bases his case, comma, is valid in the eye of law. Full stop. Next para. Insofar as the counterclaim of the respondent numbers 3 small a and small b is concerned, comma, since the adjudication, since the issues raised in the same are also covered by the written statement of the said respondents, comma, while deciding the issues, while deciding the shares of the parties, comma, the contentions of the respondent numbers 3 small a and small b in the written statement come counterclaim shall also be considered by the learned trial judge and the counterclaim shall also be decided accordingly. Full stop. Next para. As to the other grievances of the respondent numbers 3 small a and small b, comma, since those have been raised for the first time before this court, comma, we do not express any opinion on the same. Full stop. However, comma, if law so permits, comma, it will be open to the respondent numbers 3 small a and small b to seek appropriate reliefs in that regard in the court below after remand. No rest to cost.
May I submit before we lodge one thing?
Yes.
Devobroto Sinha, died already 11th of May 2023. 3 and 3B, 3B died 11th of May 2023. 3A died. And only 3B is
যেখানে যেখানে না ওই 3A and 3B বলেছি সেখানে থাকবে কোন কোন জায়গায় বলছে লার্নার অ্যাডভোকেট ফর রেসপন্ড নাম্বার 3A ওটা B হয়ে যাবে
only 3B will
না তাহলে একটা কাজ করি। No, but the objections were taken by A and B both.
But within the pendency of this appeal, my lord, clear that. So, my lord,
Whoever he will declare the shares of the parties we have said. So only the surviving parties. We will put in some surviving parties.
only, my lord,
Yes. Yes. Next. তিনটে ওটা এবার ডাকবো, দেখে নাও যদি বোথ সাইড থাকে তাহলে শোনো। Mr. Chaudhary is not there.
My lord, he's just on his legs. My lord, maybe 2-3 minutes he'll be here.
Let us call the next matter. But if we take up an appeal now for hearing, then it will be difficult. দেখি কেউ টাইম ফ্রেম নাই কেন পটেটা। Mr. Dhar, we'll just take up a continuing matter at 3. Mr. Chaudhary is coming. We'll pass it over for your matter for the timing. We are going on passing over these matters. We are waiting for Mr. Chaudhary. If he does not come by 3, then we will take up your matter. 3 is 2 minutes left. I will give him 5 minutes. Pass over. Pass over item.
24-25 is the 3 p.m.
Respondent is there.
Respondent is not there, madam. They were not appearing. And in pursuant to your lordship's direction, we have also given them a notice also. In spite that, probably no one is appearing.
So we'll take up the matter. We'll passing it over.
But in item number 20, my lord, Mr. Ujjwal Rai is appearing on behalf of the appellant, my lord, seeking for 1 day accommodation, my lord.
Respondent.
Appellant, my lord.
I am for the
I'm
respondent.
sorry, my lord.
Give your names. No. Need not change sides.
I'm sorry.
Give your names, both of your names. On the prayer of the appellant, the matter is adjourned for the day.
Item number 29.
None appears for the parties at the time of call. Let the matter stand adjourned for the day. We have adjourned for the day. Yes, next.
Item number 31. Item number 30.
But I beg to appear on behalf of the respondent number 1.
So what is it? Both of you are ready? Then we'll pass over because we are waiting for a matter, Mr. Chaudhary. Just pass over.
Item number 31.
Your lordship, paying to short pass over.
Pass over.
Item number 32.
32, 33, 34, 32, my lord, I am appearing for respondent opposite party.
My lord,
I am praying for extension of time to file affidavit in opposition.
Opposition, we are hearing the appeal. There was a direction.
The additional of evidence and application has filed by the
32 and 33.
32, 30.
There are 3 matters being taken up together. Oh,
32, my lord,
so 33 and 34 are cross objections of the same appeal. So you are for the other side, appellant.
No, my lord, I am for the SBSTC cross objector, my lord. Ms. Deboshree Dhamali is appearing.
You are for the appellant. You are for the respondent. Which respondent? Free India.
I am praying for extension of
In item 32. Learned Counsel appearing for the respondent in FA 20 of 2019 within bracket Messrs. Free India Dry Accumulators Limited bracket closed seeks an extension of time to file affidavit in opposition to the pending application under Order 41 Rule 27 of the Code of Civil Procedure. Full stop. Accordingly, how much time? Accordingly, the time for filing opposition to the said application is extended for a week from date. Full stop. Reply, if any, shall be filed within a week thereafter. The FA 20 of 2019, along with the connected cross objections, shall next be listed on February 19, 2025. 19th February. ওটা হ্যাঁ এটা দিয়ে হবে এটা দিয়ে একদম যেখানে যেখানে এ বলেছি এ মাথায় আছে বি আমি ভুল করে এ বলে বি হবে আর যেখানে দুটো ইউজ করেছি দুটো থাকবে যেন না peers, let the matter stand adjourned for the day. Same order.
Respondent.
None appears for the appellant, although the respondent is represented through counsel. Stop, let the matter stand adjourned for the day. না এবার তো আপনি 500 ওয়ার্ডটা ডেকে নিন 24. We cannot wait any further. Are you ready with the reply?
My lordship will permit me, my lord.
Yes, do it. Very short point.
My lord, at the cost of my lord repeating, my lord, may I just trouble you once to come back to the contract clause once again, which, my lord, you will find, my lord, at my lord page 26. That was clause 6. Clause 6 lordship has seen.
এটা পেপার বুক ছিল হ্যাঁ পেপার Yes, clause 6.
Clause 6 your lordship has seen. Clearly, my lord, there's a 3 month. I, my lord, also want to show you, kindly, my lord, also comes once to clause 13 of the contract, which, my lord, you will find, my lord, at page 32.
Yes.
My lord, starts at 31, my lord, and then, my lord, see, my lord. So that is, my lord, if you see, that is also termination, which, my lord, envisages a termination in certain specific cases where, my lord, there is misconduct or related issues on the part of the employer. There, my lord, my lord, the clause says no notice period is also required. What, my lord, I am essentially on today is this, that the contract, my lord, is in black and white. It, my lord, envisages that today an employee can continue up to the age of 60, provided his mandate is not terminated, my lord, early. In terms of, my lord, the 3 months.
So, Mr. Mojumdar has raised a point that if there is a prerequisite for such determination, then it's not a contract which is in its nature determinable. Something else is required before it is determined.
My lord will kindly permit.
So that, what is your answer to that?
No, my lord, there is, lordship has seen the determination clause.
Yes.
There is, what lordship is thinking of a condition precedent.
No, Mr. Mojumdar's argument, if I understood him correctly, is that if something has to be done before that determination, so it's a conditional sort of determination.
Let us read that clause again.
Implicitly, in its nature, it's not determinable.
Let us read that clause, my lord. Let us read that clause again.
Yes.
Page 26, my lord.
Page 26, yes.
Lordship just gives me. Your employment is subject to the terms of this agreement for an indefinite period unless and until terminated by 3 months written notice on either side or otherwise as provided in this agreement. So the only requirement for termination is 3 months notice and either side can do it. Now I have been injuncted at a step before that.
Yes.
So where is the question of what, if I can't do this, my lord, it can't be, my lord, heads I win and tails you lose. I have been injuncted before I can even give the notice. And then it is saying, you will retire from services of the bank on that is the retirement. And so, my lord, what is the precondition that I am supposed to do? The only precondition is unless terminated by 3 months written notice. And my lord, this 3 months written notice is, my lord, it is well settled. I don't think I have to cite any law that this is a case. Why 3 months notice? Because 3 months you get time to wind up your affairs, and this is the reasonable compensation you get if notice is not done. Because, my lord, lordship knows, my lord, in injunction, when we plead that compensation in terms of money is not adequate relief. That is why we ask for injunction from your lordships. Here, my lord, the parties have indirectly agreed to 3 months salary as liquidated damages for compensation, assuming, my lord, for instance, my lord, if the termination would have been done without giving 3 months period, would they be able to come after 3 months and say give injunction? No. They will say, no, if you succeed, if it is bad, you get 3 months salary. Liquidated damages, it is agreed, compensation in money is adequate relief. So, my lord, there is no other condition which will require any trial so far as this is concerned. And their case in the suit also is that, look, they have called me, they are saying my services or my scope of work will be again reworked, and they have threatened it is almost akin to termination without following this. Their grievance is also that this 3 months condition has not been followed. And that is how the court has also understood while passing the award. In that prima facie finding, lordships have read it.
But in the absence of any alternative roles, you say your employment will terminate by reason of redundancy.
Yes.
This is beyond the scope of the contract.
No, will terminate by reason of redundancy. My lord, over here, the contract, I don't have to give any explanation.
No, you did not say that I will terminate. You said your employment will terminate by reason of redundancy.
All right, my lord.
So it lends some automatic.
I tell your lordship, there are two possible interpretations. Our interpretation was that it will be followed by another termination notice. That is what we thought, that we are giving them an advance notice that it is likely to be followed by termination. Now, what is falling from your lordship, my lord, or let us assume, my lord, they have understood this to be a termination notice itself. They have understood, it is possible, they have understood this to be the termination notice itself, and therefore the challenge is that 3 months notice has not been given. Then also, my lord, injunction, my lord, 3 months, it makes my case easier. I don't have to give 3 months from now because I have paid him salary for so long. My lord, it is only 3 months compensation. Assume for a moment, my lord, lordship holds this notice is not a valid termination notice because 3 months period is violated. My lord, the compensation is 3 months salary. Then also, my lord, the injunction should go. Whichever way lordship looks at it, my lord, firstly, it is determinable in nature, my lord. This is absolutely clear. Now, if this is treated to be that it has already been determined, because, my lord, the court has not understood that it has been determined. Court has understood it as a threat. Be that as it may. If it is taken to be as a final determination or that it has come into effect, my lord, so far as reasons are concerned, it is neither, my lord, it could have also been, my lord, I do not like your face. But I am
need not have been that also. You give 3 months notice, you will be terminated after 3 months.
3 months.
If you give 3 months, then nothing is
But
required.
it is, my lord,
And as per clause 13 placed by your learned friend, then you would have to, there might be scope of giving reasons because there are grounds for that.
Yeah,
This is not a 13 scenario.
that is on a different aspect. We are only on this one, and that is why, my lord, even on the previous day, I told your lordship that whichever way lordship holds, my lord, lordship can record we are going to pay 3 months salary even from today. Though, my lord, 3 months have already, he has received it because he only now comes to the office, sits for the whole day and goes out. Because of this injunction, and we are being compelled to give the salary.
There is another perspective to it, Mr. Chaudhary. Suppose we don't hold that this is a termination notice, but this is a prospective sort of termination notice in the sense that you say you use a 30-day phrase, 30-day consultation, and he'll continue to receive full salary till that period. And in the meantime, you will consider alternative roles. If it is not found, then your employment will terminate. So let us presume that you are proceeding on the premise that if no alternate role is found, then you will issue a notice. And then also this notice, this contemplates a mode of termination or a reason of termination which is unknown to the contract. Redundancy and all these things.
Well, contract does not take into account any particular reason to be given to terminate.
No, then you have to issue a notice. We can do this. This is one of the possible options.
Lordship vacates the injunction, we will.
So we can say that this is. We can also say, this is one of the alternative options. we are thinking out, we are exploring in our mind that this is not a valid termination notice, but if this is not a valid termination notice, you cannot act on this to terminate it per se on the basis of this.
No, I am not saying that.
But this does not prevent you from issuing a fresh
My lord,
notice.
Lordship would record, my lord, as what is notice, my lord. It is putting him on notice that I am.
No, you have to then give a 3 months notice. This
From
will,
today, 3 months.
whenever you give the notice, from
Lordship
that,
will record my submission. From today, 3 months, I will give 3 months salary from today.
you have not given a notice at all.
My lord, I
So
am.
it cannot be like that.
My lord, it is because of the injunction that was
Yes, that
subsisting.
is what we are saying. We can,
So, my lord,
we can think about an option. One of
in
the options
effect,
would
what
be
has been done is
one of the options, Mr. Chaudhary, would be to free you from this. I mean, this, even if you cannot give effect to this, independent of this, you can issue a notice of 3 months and have them terminated if you are
Lordship,
under 6.1 in accordance with law.
yes. It will not bar me. Well, that is all I want.
This is one of the options we are thinking about.
The injunction will go. My lord, it should not be. The injunction has to go because, my lord, under no situation, my lord, let us assume even if it is interpreted the way your lordship has done it just now, my lord, then also, my lord, there cannot be an injunction on me that I cannot act on this.
No, you cannot act on this because if you act on this, Mr. Chaudhary, subject to your other points. I mean, if the suit is not maintainable or prime official, because if you can act on this, we can at best say that this injunction will not prevent you from issuing a fresh notice of 3 months in terms of 6.1 and get them terminated. But if you act on this, then what happens after the consultancy period?
No, my lord, that
will
period is
automatically
over.
terminate.
My lord, whatever little scope of considering him in an alternative role which was there, my lord, that has been, my lord, that has been severed because
So then
of
we'll
the
have to record that it has not terminated pursuant to this notice because it is not a termination notice at all.
Yes, my lord, we were considering now, my lord, with litigation, there is no question of any alternative role. I have taken instruction, my lord, whatever consideration could have been done, it is now severed because of that. So no question of that, my lord, lordship will do that. I am not saying that I will construe that as termination notice and, my lord, 3 months from there. But I will pay him for the 3 months, but I don't want him in the
So
organization.
then you'll have to issue a fresh notice and
Well, lord, tomorrow I'll do it. Lordship will vacate me or permit me, my lord. I'll do it. I said that on day one. I'll give a fresh notice.
yes.
Today, not with the change provision, not the initial embargo that an
Mr.
employee,
Majumdar, you had your chance.
only not apropos the observation that fell from the court.
Very good. Yes.
That an employee cannot be reinstated in service to the civil court's invocation of jurisdiction, probably that is not the law as of today, by reason of the change situation in to the amendment. I can get reinstatement in service through a civil court. If that be the interpretation of,
But that does not prevent them from terminating you in the first
that
place.
not
You have sought an injunction from terminating you.
today the bank seeks to justify its stand apropos the notice of 29 January 2024. Please read the notice of 29 January 2024 once again.
Yes.
But I believe lordship's copies are not very happily legible.
No, it's all right. You have.
They have given a type.
Another copy has been given us.
I will write further to our meeting today to discuss your role with the bank. As explained as part of a recent review of the personal loans business, the bank considers that we will source personal loans only from alternate and intra-bank channels going forward. Unfortunately, this means that your employment is at risk of termination due to redundancy. No, that's exactly not what it pinches.
At risk, not terminated.
Right. Now, not so, they are incorporating something in the contract which was not born from the agreement.
Mr. Majumdar, they are fair enough to give you a reason. They could not have done it. They could have just given a 3 months notice and terminated
Now,
you.
please come to
6.1 is
page
clear.
31, which was being placed.
Yes. No, this is not a 31 scenario. If 31 is there, then many other things could come
Okay,
in.
no, it was probably it comes under clause B.
No.
My failure to perform duties would attract clause B.
No, they do not say that they do not give any make any allegation under B. They say redundancy is something else.
No.
You are superfluous in the company now.
Please come to.
This is sort of, I mean,
Dependency. I am not required by the company.
not required by the company.
By reason of not say.
If a company can't do that, Mr. Mujumdar, it would be, yes, they have to follow the law. Every other aspect of law has to be followed. But if a company cannot do that, they cannot downsize ever.
If I can produce a document to show that I am being removed and persons are being put in the same place.
That we cannot go to that extent.
So to that extent, the court is trying. The court is exactly trying the issue of not the justifiability of this notice. It's for the bank to very easy for the bank to come up and say that we will come back with fresh reasons or a different stand. But today the trial court is exactly trying the justifiability of this notice, and I have a right or probably an opportunity to show to the court that you are inducting persons in my place, and this is only a facade.
Mr. Mujumdar, where is your plaint relief? Which page?
It's at page, begins at page 42.
Achha. Probably at page
56.
4 it starts.
54, yes.
Right. Very well. Mr. Chaudhary, because you are saying 5th is the next date, we'll reserve judgment on this. We have to think. We were thinking that we'll pass it right now.
Very well.
We'll reserve judgment, but Mr. Mujumdar and Mr. Chaudhary will say that we are reserving judgment. Any further order passed in connection with the injunction application shall abide by the result of this.
But
because otherwise, they will suppose they win, they'll have to prefer another challenge against the extension.
But the special bench has already heard out that point, I believe.
Which one?
For every extension, whether a separate application is required to. Three-judge bench has already heard that out.
Heard out.
Judgment is reserved, I think. Understand as far as I know.
Heard none at counsel for the parties. Hearing is concluded and judgment is reserved in the matter. It is made clear that any order which may be passed henceforth in connection with the injunction application by the learned trial judge shall abide by the outcome of the present appeal. Thank you. এটা ধরে পাঠিয়ে দেবেন এটির মধ্যে আপনাকে দেখিয়ে দেব ওই ইয়ে করে 6 তারিখের পর এবার পাসওয়ার্ড গুলো পড়বো একটা পাসওয়ার্ড যখন দেখেছি এবার বাকি যেগুলো পাসওয়ার্ড হয়েছে আবার ডাকতে স্যার Yes, order number 3. Before we begin, Mr. Dhar, how is your clerk or your staff?
He presently he is all right.
Yes.
And after thorough checking and investigation, they told he had some difficulties. Maybe for not taking the medicine for his pressure for last 4 days. It is unfortunate. But however, they have suggested for taking rest.
Very
He has been to his house tomorrow, yesterday. And I told him not to come tomorrow, that is today. Take rest for
Fair
2
enough.
weeks and then come.
Because Mr. Dhar could not attend at the first call yesterday due to his that reason.
Yes.
Yes,
I
Mr.
was confined.
Yes, what is the matter? Mr. Ray, please take your seat.
Not only one thing, on the last day, I raised a preliminary question.
Yes.
They filed a suit for basic performance contract. I filed counterclaim, recovery of position.
Oh, yes.
My lord, I pointed out on last.
Recovery of position has been granted.
Recovery of position granted and basic performance fails. But appeal is one appeal. Whether this is at all maintained.
Mr. Rai, because it's recovery of position, because specific performance is an actionable claim. It's not a present right. They don't have a present right. So if their title was title suit was dismissed, we could have understood. Irrespective of the outcome of this, you can proceed with your recovery application. Suppose they do not challenge the recovery and they get a decree here. No, then it will be difficult. You're right.
I was
Yes, Mr. Dhar, what are you? Yes, Mr. Ray is right.
considering this question.
Yes. Even if you will, if you lose this appeal, there is no difficulty. But if you win this appeal, there is no challenge as of today against the recovery decree for recovery of possession.
It has been under challenged.
Where?
It's under challenge. In
Separate appeal has to be filed then.
No, the
Counter-
appeal, since your lordship, the
Counterclaim is the nature of a suit.
impugned order, the impugned order has been passed in favor of the defendant number 3 before your lordship is the respondent number 3. Only because of that, my suit has been dismissed on the ground of limitation. But
Mr. Dhar, if you win this appeal and you get a decree, we pass a decree directing a deed to be executed in your favor, then also that will be in the teeth of the recovery decree for recovery of possession.
this decree also challenged in the
You cannot challenge in a separate single appeal. That's well settled.
consolidated order.
It cannot be counterclaim. There has to be a challenge, separate challenge. Mr. Rai is right on that. That's well settled since long. If there's a suit decree and a counterclaim decree, counterclaim is on the footing of a separate suit. But Mr. Rai, you have to consider one other aspect also. Suppose they do not challenge that recovery. They are subject to whatever happens in that recovery. Now, if that recovery suit, suppose you get it executed, they can always come back after they get a decree in this suit, if they win this appeal. After they get a decree, they can always go to the court and ask for recovery of possession back again.
Irrespective of my degree.
Irrespective of your degree.
That's why
But that is the confusion. You are obviously all of us are.
Yes, yes, my lord. Yesterday, my lord, I also submitted to your lord. I am carrying some confusion on it. Honestly.
Yes,
submission,
yes.
honestly submission. Because
yes.
Counterclaim is an independent suit.
Right. Not mutually exclusive.
Not with independent
Exactly.
suit. In all fairness, they should have come with 2
No,
appeals.
they should have preferred a challenge against that. But if they don't prefer a challenge against counterclaim, that decree remains. You can get your decree executed. And even if you get that decree executed, that does not militate against their getting a decree here. Because they don't have a present right. As of today, they are not owners of the property. Irrespective of whether they win or lose in this appeal. So as of today, you can get, it's not contradictory. I mean, even if they don't prefer a challenge against the counterclaim, counterclaim remains. You get a degree of eviction, you have him evicted. If he wins this decree, he will get a title to the property. Then he will have to probably file another recovery of possession suit against you. But he is taking that risk. But that does not mean automatically the appeal is not maintainable.
He has to make sure which order judgment he is preferring appeal. He is not sure.
Yes, you have to clarify that.
That is the,
That you have to clarify.
I follow my lords. He has to
You're
follow.
right. You're right, Mr. You cannot have advantage of a challenge to both.
He cannot challenge the
No.
decree as a whole by to.
No.
It is
There is
at
no
best
separate conclusion or separate findings for the
Need not be counterclaim
for
is a
the
separate.
counterclaim.
Mr. Dhar, if two suits are heard analogously, common judgment is passed
Yes.
and decree is passed, there have to be two appeals because decrees are two, judgment is common.
If there are two judgments, if in a consolidated
No,
order,
if in an analogous, that's basic, Mr. Dhar. If there's an analogous hearing of two separate suits, a common judgment is passed, two decrees have to be passed, and two decrees you have to prefer challenge against both the decrees separate by separate appeals.
that has not been done
And
here.
in this case, counterclaim is on the same footing as a separate decree. Well settled counterclaim is a suit for all practical purposes. There also written statement is filed, whatever. Therefore, counterclaim has the footing of a suit. There are, for all practical purposes, a common judgment, but there are two decrees, one allowing his counterclaim, another dismissing a suit. So unless you prefer a separate challenge against both, you have to choose. The doctrine of option is applicable. You have to choose. Your election is now on you. Which one are you challenging?
In this case, your lordship, that I am already owner of 2/3 portion.
No, but
Two-third portion.
which part of the decree are you challenging? The dismissal of the the allowing of the counterclaim?
I am challenging the
Page
dismissal of the
157,
dismissal
memo
of
of
the
appeal. Memo of appeal. Lordship, kindly nothing, no specific specification which has been challenged. I have seen it. That's why, my lord, it's troubled me also, because I should assist the court.
So since it is a consolidated order.
No.
And there is no findings.
Separate decrees.
There is no
Counterclaim decree is a decree.
No, I agree.
Lord,
with
you kindly turn to
You have to file two appeals
I
against two
agree with you,
decrees.
Lordship, but
One
in
page-
this case,
page
in this
157
case,
of the
there
paper
is
book,
no
memo of appeal.
separate findings for the counter
Memo of appeal, Lordship can see.
and the counter claim has been filed.
So we'll
only-
treat this to be an appeal against the title suit decree.
As a whole.
No, only the dismissal of the suit, because
as a whole.
Not as a whole means the decree, dismissal of the suit as a whole. There is no question of as a whole. Counterclaim is not covered. In his preamble, he does not, if he said along with the decree passed in the counterclaim, then it would be a bad appeal. But here he says, with the judgment, agreed with the judgment and decree passed in title suit number such and such. He does not even mention the counterclaim. So we'll record at the outset that this is, we treat this as a challenge.
That I want, he should make clear.
Even if he does not make clear, we'll make it clear at the outset before taking up for hearing. Mr. Dhar, you have to elect between whether you are challenging the recovery of possession decree or the dismissal of his suit.
The dismissal of the suit, of course.
We'll record that and start. Go ahead with your recovery of possession. We'll record that then. At the outset, learned counsel appearing for the respondents takes a preliminary objection to a single appeal having been filed in view of the learned trial judge, by the impugned judgment and decree having passed a common judgment but two separate decrees, dismissing the suit for specific performance of the plaintiff appellant in the one hand, and on the other, decreeing the counterclaim of the respondents for recovery of possession against the plaintiff / appellant. Full stop. Next para. It is submitted that since a counterclaim stands on the same footing as an independent suit, the effect is that although by a common judgment, two separate decrees were passed. Full stop. It is argued by learned counsel for the respondents that in the absence of two separate challenges against the two decrees, the appellant is required to specify as to the scope of his challenge, whether against the dismissal of his suit or the allowing of the counterclaim. Full stop. Next para. Learned counsel appearing for the plaintiff appellant submits that since a composite judgment was passed, two separate appeals are not necessary for assailing both the dismissal of the suit and the allowing of the counterclaim granting recovery of possession. Full stop. Next para. However, we are unable to accept the contention of the plaintiff on such count. Full stop. The effect of a counterclaim in the eye of law, for all practical purposes, is akin to that of an independent suit. Full stop. As such, the position in the present case is similar to a case where two suits are heard analogously and by a common judgment and separate decrees, they are decided separately. Full stop. In the present case, since the counterclaim of the defendants respondents has been allowed, which constitutes a decree in its own right, and at the same time, the suit for specific performance of the plaintiff has been dismissed, by a common judgment, in the absence of two separate challenges, the plaintiff appellant is required to elect whether he has assailed the dismissal of his suit or the allowing of the counterclaim. Full stop. At this juncture, upon such query being put to the learned advocate for the appellant, learned advocate, in no uncertain terms, submits that the present appeal has been preferred against the dismissal of the plaintiff appellant's suit for specific performance of contract. Full stop. Accordingly, we proceed to hear the appeal on such premise, keeping it on mind that no separate appeal has been preferred against the decree allowing the counterclaim of the respondents for recovery of possession. Yes, please proceed with the hearing.
My lord, I have also submitted that there is no specific findings in respect of the findings of the court below in respect of the counterclaim before the decree was.
There is no decree of count. How can it be?
No, no specific findings has been recorded or specific finding has.
If your this decree, if your prayer for specific performance is refused, it follows automatically. What remains? You are not entitled to remain in the property. Did you take a section 53A defense in their counterclaim? TP Act. If you did not take a section 53A defense, then there is no defense in this suit.
No, that defense, in the suit, my lord, kindly come to the impugned order. I am following the certified copy of the judgment.
No, we have a paper book before us.
Kindly come to the page 148 of the paper book.
Yes, Mr. Rai, you want to say something? You want to say something? Take your seat. Yes. 148, Mr. Dhar.
148.
That's the middle of the judgment.
It's the middle of the judgment. Regarding the findings only.
Achha.
In respect of the counterclaim.
So counterclaim, we are not entertaining you because we have just now elected. You have just now elected to prefer the challenge against only the dismissal of your suit.
Yes, yes.
So argue on that only.
Since your lordships have already expressed your lordship's mind that your lordship is it is confirmed that the two challenge cannot be made in one.
Yes,
appeal.
that we have decided.
In cases of
counterclaim and suit.
Counterclaim, suit and counterclaim. So I had to do that.
That is settled since long before the birth of our grandfathers.
Yes, I agree with you, Lord. The Order 41, Rule 1 says like that.
What does Order 41 Rule 1 say?
Order 41, Rule 1, there is no specific provision in Order 41 to file a single appeal also for suit and the counterclaim. A decree from the counterclaim and the suit.
Yes. So let us proceed with the appeal. Yes.
Kindly come to the page 148, the second paragraph.
140, you won't place the judgment before us? Start from
This is impugned order. This is judgment.
148 is page 23 of the impugned judgment.
No, that is 26 is just starting. I am coming to the particular point. Coming to a particular point.
We need to go through your pleadings also. What was your case? Let us start from the beginning.
The case is this, your lordship. Kindly take the list of dates at first.
No, let us read the judgment first, then we'll go to that.
Right. At page 126.
Yes.
It suit coming for final hearing in the presence of the Prashanto Chakraborty, advocate, the plaintiff, petitioner.
Oh, your recovery of possession has been granted in respect of 1/3 only. Mr. Dhar, 1/3 only. Have you seen recovery of possession has been granted in respect of 1/3 of the garage? The rest 2/3 it has been held that you.
What has happened? What has happened? The 2/3.
Yes.
I am stating the fact at first, your lordship. one Sukumar Datta was the original owner of the premises.
Right.
He sanctioned the plan and then took advance as a booking money and a loan of 40,000 and booking money of 10,000 for a garage space after construction, rebuild and construction of the building and the completion of the building. He used that money for the purpose of construction, and thereafter he entered into an agreement with a promoter. That is PW2. After completion of that building, he took a further sum of 50,000 and entered into an agreement for sale with the plaintiff to sell him at a price of 1,05,000 on obtaining the completion certificate from the KMC.
This is only in respect of a garage space.
Garage space. It is a garage space of 140 square feet. After obtaining the completion of the building, obtaining the completion certificate,
yes,
he prepared the draft of the agreement. But unfortunately, after purchasing the stamp, suddenly he passed away after suffering for 3 days in a malignant malaria. At the time of the entering into the agreement for sale, he handed over the possession to the plaintiff.
It was a registered agreement for sale.
It was not registered in 96, before this amendment.
Right.
Before this amendment. Now, my lord, after the death of the original owner, his widow, son, and daughter, they initially agreed to execute the deed of sale, but subsequently the daughter refused. Then a notice was issued to them. They refused to, and a copy of the deed of sale was also handed over to them. They refused to execute it.
Copy of the draft deed of sale.
Copy of the
draft deed of sale.
Yes, draft deed of sale. They refused it. Subsequently, the suit was filed.
Yes.
On refusal. Now, during the pendency of the suit, 1 and 2 agreed, and 1 and 2 executed the deed of sale for their 2/3 share.
All right.
And took the balance money out of 5,000 remained at the time of agreement for sale. It was registered. There was no difficulty. The suit continued. The 1 and 2, the 2 also examined. All documents were produced. The defendant number 3, the respondent number 3 before your lordships, only denied the actions claimed by the plaintiff. Only denied his claim made in the plaint. Initially, your lordship, it has been agreed by filing an amended written statement by the defendant number 1. Hence, he agreed that as the defendant number 3 compelled him to file the counter claim, she did it. And subsequently, she filed an written statement, amended written statement, admitting all this action done by her husband. Now the question arose at the time of final hearing regarding the limitation.
It has been dismissed only on the ground of limitation.
Rejection.
It has been dismissed only on the ground of yes.
For dismissal of the suit. That is Article 54.
Yes.
Article 54 of Limitation Act.
Yes. Act. Limitation Act. No, Mr. Dhari, continue. We'll have it in a minute.
I have.
Our copy looks better than yours, so we'll keep on. Please continue with the argument.
I agree. Your Lord.
Mr. Dhar, because we got it later than you. Nothing was here. While taking up civil matters, we have been asking for books, and now they have brought more or less all the books. So let us start with that. Yes. Section Article 54 was invoked.
Article 54 was invoked.
Right.
What has been done by the
trial judge?
Trial judge, learned code of the learned code below.
Now you cannot say code below. So learned trial judge. We cannot put lower court.
I also in same opinion.
Be very cautious.
We should not utter the code below to respect the institutions. So
the difficulty is, Mr. Dhar, when you admit second appeals, previously we used to say both the courts below such and such.
Yes.
So both the courts below made a concurrent finding. We have, at least we say that the learned trial judge as well as the learned appellate judge did this. So we have to spend 6 words more. So the limitation starts for specific performance of contract.
Limitation starts if the time is fixed and specified in the agreement.
When you have notice that the performance is refused, if there is no fixed time in the document, in the agreement.
There is no.
In the agreement
there
was there
fixed time, but it was little bit confused.
Achha.
Kindly, your lordship, come to the exhibit 3 in the paper. Exhibit 3 in the paper book at page 194.
Some of the papers are threatening to come off in our hands. 2007 appeal, yes.
Is it correctly handed over?
Pardon?
Is it correctly handed over?
Correctly?
Correctly handed over, the same. This paper book.
No, the paper book's right. I mean, it's so old, the papers are coming in our hand. That's what we are saying.
There is a lining in the department since 2007.
Yes. Yes, Mr. Dhar. So where is the confusion? Court proceeded on the premise that there was a specific time given and calculated limitation on that.
Calculated limitation on that, no. He's also in different other which is not also in the agreement. Your lordship, kindly come to where the particular the time fixed.
Yes.
That is at page 196 of the paper book.
Yes, we are there.
In paragraph 1. I am reading the whole paragraph.
Yes, yes.
The vendor shall sell and purchaser shall purchase the covered space measuring more or less 140 square feet built up area of on the ground floor of the building be made over to the purchaser after completion of the construction within 6 months from the date of agreement for their use and occupation, inhabitable condition and at premises number so and so.
This 6 months is the sticking point.
6 months, but the sentence continued. Sentence continued for 6 months from the date of agreement for their use and occupation. Inevitable condition. This is relevant. This much is relevant. But the whole sentence is really confusing.
Why?
It does not speak anything. 6 months from the date of agreement. Your Lordship, kindly come to for convenient, your Lordship, kindly come to the list of dates.
Yes.
The list of dates.
Okay, moving on.
14/10/95.
Yes. 14/10/95.
When the agreement was executed. That item number 5.
Got it.
The next one, the item number 6, 7/2/97. After completion of the construction of a 4-story building, the Shukumar Datta obtained the occupation certificate of the said premises on completion of the 4-story building from the Kolkata Municipal Corporation.
Yes.
It was never made completed within 6 months of the agreement.
All
so
right.
it cannot be taken up. And in this case, your Lordship, why the limitation cannot be considered in that way, that the original person who made the contract and agreement, he was no more. He had all the intention to execute the deed of sale. Unfortunately, after purchasing the stamp papers, he passed away. That limitation cannot run for his next generation. And the person agreed. One of his heirs did not agree to execute it.
Then when the heirs refused, you say the limitation starts from that.
But yes, the second provision of Article 54 of Limitation Act.
All right.
And I am also covered by, your Lordship, the funny thing is that, your Lordship, the learned trial judge relied upon 2006 Supreme Court, where it has been, though it is not actually applicable, principle is there. Once it is changed or extended, then the second proviso, second proviso of Limitation Act will apply. That is from the date of refusal. In my case, is 1999, they refuse.
All right.
And the suit has been filed in the next year. Within 6 months. Not within even 6 months. Your Lordship, there is another provision in the next page of the agreement. The purchaser shall send the draft conveyance to the vendor. That is up at the page of 197.
Yes.
To the vendor after making over possession of the covered space of the said building, and registration shall be completed within 1 month from the date of making over possession of the said covered space by the purchaser. That possession has been given, it has been already agreed that possession has been given on in the month of June, end of June 1997. The DW1 also agreed to that. It is admitted in their written statement. The possession had been handed over on 97, June 97, and the stamp paper was purchased on 21st July 1997. And unfortunately, the intended seller, the Shukumar Dotto, passed away on 25th July 1997.
Yes.
There is no non-compliance. There is no question of further considering the limitation. And on his death, it should be extended. It has been automatically extended. The limitation cannot be taken up. And due to that confusing statement, confusing sentence in the agreement, it cannot be calculated in that way. And in addition to that, the building was not completed within 6 months from the date of agreement for sale.
Right.
And possession has been handed over just after completion of the building. I am pointing out the judgment, Your Lordship, where it has been considered.
Yes.
To make it short, my lord, I am directly coming to
Please,
that.
please, yes, absolutely.
There is no use for
No news beating
reading
about the
whole
question.
judgment.
Yes, yes.
Kindly come to the page 146.
Yes.
I am pointing out the findings, not the findings, but the submission which has been recorded by the learned trial judge. It is submitted by the counsel appearing on behalf of the plaintiff that as the recital of Exhibit 3, the construction of the building of the shoot premises was not completed within 6 months from the date of the agreement as per recital as per recital
As per recital, the limitation will run
the
6 months.
recital, the limitation will run 6 months after completion of the shoot building, and not within 6 months from the date of execution of the agreement. But I am not in agreement with the argument advanced by the learned counsel of the plaintiff. I find that there is clear recital in the agreement deed, and it speaks that the time is fixed for execution of the deed of conveyance within 6 months from the date of agreement. The learned counsel referred to a case law reported in 2006 Supreme Court, page 40, where it has been held that the suit for specific performance of contract, the time of limitation under Article 54 run from the date fixed in the agreement. If by any subsequent letter the defendant requested the plaintiff for postponing performance to further date without fixing any further date for performance, the time for performance stands extended. This is the proposition of in that case, your lordship, in 2006, what has happened? The intended seller.
But there, Section 18 of the Limitation Act came into play.
My lord?
Section 18 of the Limitation Act in that case came into play. Section 18 says, where before the expiration of the prescribed period, an acknowledgement of liability in respect of such property or right has been made in writing. If an acknowledgement is made, then limitation gets extended.
Yes.
But in your case, there was no acknowledgement in writing, but by conduct
was
Sudhir, whatever, Sukumar Datta
handed over the possession.
Handed over possession in pursuance of the agreement, completed construction beyond 6 months, handed over possession to you, thereby acting in terms of the agreement. So you say that time is not the essence of the contract.
During his lifetime, the deed of conveyance was prepared.
Yes.
By purchasing it has also been proved by filing the exhibit, and ultimately it has been proved that the stamp paper were purchased and it was prepared, but unfortunately within 4 or 5 days he passed away, living in unregistered. Then Section 53A will come, part performance.
In your written statement, have you taken a defense of part performance? But you have stated that your
possession was not required at that point of time.
Possession was.
It was at the end of judgment, it was decided. There is no such argument on limitation prior to that. Only this much.
But issue was framed.
Issue was, your lordship, kindly come to the issue, how it was.
Issue number 2 is limitation. Is the suit barred by limitation?
Issue was framed on that point. Your lordship, kindly come to the issues. One.
You have seen the issue.
No, it is actually, if your lordships come to the issue in the record, the impugned order in the record, that is why I have taken the certified copy of that one. After the judgment and order was passed, then the issue was framed.
What? Issue finds place in the judgment.
Issue has been placed.
How can issue be framed after the judgment is passed?
By writing in a hand.
How can the son
handwritten issue?
How can the son be born before the father is born?
That I do not know. Why
find the issue at
why it is handwritten? I do not know.
You argued on limitation. Your arguments are recorded
argument was in limitation.
Then
only for fixing for that purpose.
You have
Only
argued on
respect-
limitation.
That point has been
Yes.
argued. That point has been argued. Actually, the AIR 2006 Supreme Court is not applicable in my case also. That there is no question of extension, the principle can be taken.
Mr.
And
Dhod,
date of the intended seller also to be considered. That who disagreed, who refused. Out of 3, 1 refused.
Mr. Dhod, we are putting you on notice. We will consider one judgment because while going through this, we are just seen the annotation. We don't know what is there in the judgment, but you please just take a note. No, we are putting you on notice. We will consider this judgment. 2015 8 SCC 390. Please take a note. Your learned assisting counsel does not have a pen or paper. Page 390. 2015 8 SCC 390. Whatever, I mean, we don't know what is there. 2015 volume 8 SCC 390. Because we find from this annotation, which are often misleading, Article 54 does not distinguish between a case where possession of property has been delivered in part performance of agreement or otherwise. That may go against you. We don't know. We have not seen the judgment, but we are putting you on notice. We will consider this judgment so that you can argue on this judgment also when you proceed.
Then I have to consider.
Yes. The rest of the argument will conclude today. We will keep it on some other day for this part only. You can ask your learned friend, he's assisting you in this matter. Ask him to get a copy from the library. In the meantime, send his clerk. Your clerk is in the hospital.
No, he is my bearer.
He's on holiday. His
But
clerk.
if it is not available,
we'll think about that then.
may come back or with after.
No. Complete the rest of your argument. This is the small scope of the argument, Mr. Dhod. This is the only. You say time is not the essence. No, still much left.
No. If I send them, they will say after 4.
Mr. Dhod, if you understood you correctly, the suit has been dismissed only on the ground of limitation, Article 54. The court was of the opinion that since the agreement stipulated that it has to be performed within 6 months from the date of the agreement, the first limb of Article 54 is applicable. Therefore, limitation starts from that end of that 6 month and you are time barred. You say no because the original vendor, the agreement, yes, the owner, he not only completed the construction after that 6 months, handed over possession to you and never refused. Therefore, time was not the essence of the contract and that 6 month time was given a go by basically by both of you by handing over possession later without refusing. So, first limb does not apply, then the second limb comes into play, that is from the date of refusal. And that refusal took place by his heirs in the year 1999, you filed the suit in the same year. So, this is your entire argument and 2006 is probably not applicable because there was a writing which comes under section 18.
The provisions made in the agreement cannot be considered as there is a second position also. There is a second provision in the other page. In paragraph 2.
But isn't that subject
that
to
after completion of the building, after obtaining the completion certificate, he has to hand over the possession and within 1 month from the date of completion, he has to execute the deed of sale.
Very well. Yes.
If there are 2 contradictory provisions, then I have to go for the second option.
All right.
These two provisions are different.
That argument was also made by you, disbelieved by the trial court. We saw that this argument was made by you. That's not 6 months from the date of the agreement, but from handing over possession.
Handing over possession.
You have made this argument in the court below. That has been turned down.
In 2006 Supreme Court is not also applicable in my case. I do not know about this 2015's judgment. I have not.
We also don't know. We'll also go through that.
I will go through it.
Well, let us hear Mr. Rai on the rest of your argument, and we'll keep it only on this. On the next day, you'll just argue on 2015 if you have to add anything. And
One
Mr.
more submission
Yes.
in respect of my learned friend regarding maintainability of my appeal. This appeal.
That we have dealt with already. His only point of maintainability was regarding the.
Also, Your Lordship, while the appeal was admitted, he is challenging it for the first time at the time of.
There is no
I am
admission.
talking about. I am
There is
submitting
no
about
admission.
maintainability.
There is no admission hearing of a first appeal in our court, Mr. Dhar. It's deemed to be admitted by the Registrar General under Order 1411. Therefore, he did not have any opportunity.
Division bench.
Might have been in connection with some application, but there is no admission hearing under Order 1411 for first appeals in our.
No, admission hearing, it was admitted after hearing, after allowing the petition for praying for stay. At that point of time, it was considered that in spite of good service, none of the respondents are appearing.
No, we have not held that your appeal is not maintainable. We are hearing you on it. We have not held that your appeal is not maintainable.
I'm taking that additional ground to oppose my learned friend, that this point should be taken up at the time of admission of the appeal.
All right.
The appeal has been admitted.
Admission of appeal, there is no hearing for admission of appeal in first.
No hearing.
So at the first possible opportunity, they should have taken.
He got that opportunity.
When the stay application was moved.
When the stay application was moved.
All right.
If it was taken at the time of hearing of the stay application, then it might not be admitted.
Stay could have been dismissed. Appeal could not be dismissed at that point of time.
They ought to have raised.
But they are raising it for the first time.
At the time of first opportunity.
First time raising
and
here.
This should be decided before hearing of the appeal.
Very well. So let us hear Mr. Rai on the rest of this is all. And 2006 you are saying is not applicable, so we are not looking into that.
No. It is principle can be taken up.
Principle is taken.
Principle can be taken up.
Right.
And that in that case, the letter of extension was preferred by the intended vendor. In
your case, there is a letter of extension. In your case, there is no such letter.
It's not there. I'm talking about
that
2006.
case. Yes.
But in my case, the original vendor is no more. He was all through intended, but unfortunately is passed away. So the question of limitation cannot come in this case. The second generation cannot raise this point.
All right. Yes.
Can it be on next day? Can it be?
Now, if you take up any other matter, nobody will be prepared. That is a difficulty.
Because I request to see the original file. It was brought up by madam just for today. I will see here. Only one thing, my lord. Now is the question of evidence. I will show to you, lord. According to him, Section 54 from the date of execution stipulated 3 months, 6 months, stipulated. According to him, father intended to made over possession. Therefore, it doesn't apply. It extended time. If I can show from the evidence, it is not altogether different case. That's why, my lord, if I can show to you, his first case is, my lord,
Evidence must be a part of the paper book.
yes, I will show, my lord. My lord, his first argument is that father made over possession.
Yes.
Father made over possession, intended to execute, father died, his legal heirs not intended to, therefore he filed a suit for basic purpose, performance of covenant. If second limb of is that it is his onus on him to prove that actually father intended
Not intended, handed over possession actually.
and handed over possession. And this has to be proved by him conclusively. And if it is denied, if I say it was a forceful possession, that's why court passed a decree for basic performance of contract. Then, my lord, what will stand?
Yes, two other points also, Mr. Rai. One is that the construction itself was completed after that 6-month period. One. Secondly, that there are two limbs of that clause in the agreement itself. The second limb says that the construction after construction.
If it is his case that construction subsequently, then all these things he approached doesn't arise.
It's an alternative case that construction itself was completed because the agreement says that even part of the consideration will be paid after completion of the contract, completion of the building.
If I say no consideration made, nothing was paid. That is my lord, I want to bring on that. Nothing was paid. My lord will be pleased to find, I will go how the interpolation made. That's why, my lord, I today, for the sake of I want to see it.
Good.
Allow me to allow me.
We'll come back on the next working day.
Any day,
Division bench next working day is we have Wednesday, February 5th. Mr. Dhar, then you can come prepared on that judgment also. So you'll conclude your argument and we'll start with Mr. Rai.
But to reply to my learned friend, they want.
No, need not reply.
Number one,
This is
to
just
agreed.
this is just time pass. So
Defendant number two, the rest.
but you get a clue of what he will be arguing.
He
Generous in that.
He expresses that he is the eyewitness of such payment.
We'll look into that. And
And out of 1,05,000 in
Yes.
those days, the 1 lakh has been paid to the original vendor.
It is his case.
he says nothing has been paid. Nothing has been paid, and you went into possession forcibly. Anyway, Mr. Dhar, then next day, the understanding is that you will start with that 2015-8 SCC. We'll also go through that. And then you complete your arguments and Mr. Rai takes over. And Mr. Rai, you can go through the records today itself. আজকে রেকর্ডটা একটু দেখিয়ে দেবেন পরে হয়ে গেলে কোর্ট উঠে গেলে একটু রেকর্ডটা দেখুন heard in part for further hearing on February 5, 2025. Thank you. এই নোটটা কিন্তু ভালো করে রাখতে হ্যাঁ এইটা না এটার সঙ্গে একসাথে সাবধান ডাকুন পরের ক্লাস 27 ছিল না 27 কি হলো মার্ক করে রাখেননি কোনটা কোনটা পাস ওভার হয়েছে আর কোনটা কোনটা হয়ে
ডিসপ্লে বোর্ড শো করছে
কি হলো They've been served, but they're not appearing at any point of time. What is the matter about Mr. Shamul?
Suit is for declaration and damages. Damages for meddling with the carrier. I tell background of the case. The appellant appeared in a examination, entrance examination of that Polytechnic Engineering. At the first instance, there were some subjects which he did not qualify. Thereafter, he sat for the examinations.
Yes.
Results were not out. And subsequently, he was shown that he was absent, in spite of the fact that he appeared on the particular examinations. Thereafter, after so many years and several correspondence, it was found that yes, he appeared in the examination, but the authorities have lost the answer sheets. My lord, we moved a writ petition before this honorable court. The honorable single judge made some harsh comments and directed them to pay a certain amount, and also granted us liberty to sue them for compensation because of
Loss of career and all.
against that they preferred an appeal. The appellate court also dismissed using some harsh words and also extended the scope of the damages almost double. There and
No, the damage is quantified.
no, not quantified. Damages in terms of writ petition.
How can it be double?
No, it's not a damage in that sense. Is granted liberty that we should approach the trial court so that the damages can be quantified. Against that order, they also preferred a review, saying that you cannot, this division bench cannot pass an order directing them grant liberty and all this.
Yes.
That was also dismissed. In pursuant to the leave, we moved the trial court and filed this claim, quantifying, asked for certain damages. They filed a written statement. The plea of Section 80 not taken. In evidence also, this plea was not taken. In the judgment, the trial court held, as because there is no Section 80 notice, therefore suit is dismissed. The trial court tried to demonstrate in a manner that as Section 80 is a mandatory provision, therefore, and we say that this particular suit we have filed in pursuant to a leave filed by, and the purport of Section 80 has been fulfilled, therefore no need to file, no need to comply with the.
But the court only granted you leave to prefer an appeal, file a suit. But that does not mean that they'll automatically know when you file the suit, and notice is necessary.
They were contesting.
They may know.
Even for that.
No,
leave,
the culmination of that review, that entire exercise was that you are given liberty to approach the civil court. But they are not supposed to know when you will approach the civil court, on which date, or that.
On that point, I will try to
just satisfy us on that.
That is the only thing. I said that this provision of Section 80, though mandatory, but if it is filed in pursuant to certain leave or the provisions, the purpose of Section 80, if it is fulfilled, because what is the purpose of Section 80? So that the authorities, firstly, I will try to demonstrate that in this particular, these authorities, they were not coming within the strict meaning of Section 80, because I will place before your lordship the purport of Section 80, who are entitled to Section 80, and I will refer some judgments whether. And secondly, the purpose of Section 80 is that the authorities cannot come unaware. Now, in this particular cases, they were very much aware whether I get compensation of 1 rupee or I may not get. That is.
They were only aware that a leave has been granted to you to prefer a suit, file a suit.
That leave, that particular order has also been challenged. That was also turned down.
Yes, therefore, ultimately they know that you have a leave. Yes. But that leave does not necessarily mean you may not exercise that leave, or you may exercise on a particular date. How are they supposed to know when you have filed a suit actually?
And also I will place waiver, because in the written statement, as also in the amended written statement,
that is an important.
They never took this point. And even issues were also not framed. Your lordship knows, in case of Section 80, this is the first issue what we have done. First issue, maintainability, whether it was preceded by, that was also not done. Issues were also not.
So whether Section 80, the next question is whether Section 80 is a waivable objection, or is it an absolute one?
There are certain judgments which says, and your lordship knows, it's a mandatory provisions, but I came across certain judgments which I will try to demonstrate that in some cases, if it is waived by the, because Section 80 is giving a benefit, and if the person on whose benefit the Section 80 has been made, if they chose to waive it, then Section 80 is not necessary on
All
that
right.
point, my lord. May I just go straightway to the judgment, or I will play?
Judge.
Page 82. I'm just skipping the first phrase. Background facts. Panoramic background of the plain case laconically stated is that the plaintiff, after passing higher secondary examination in the year 1972, got himself admitted in the licentiate engineering course in electrical engineering stream in MBC of Institute of Engineering and Technology, Burdwan. The plaintiff appeared at licentiate electrical engineering examination in the year 1979, but was not successful in the subjects applied mechanics and engineering, estimating and costing. In the next year, he sat in the examination for those two papers, which were held on 12th May 1980 and 15th May 1980 respectively. However, in the mark sheet, he was shown to be absent in both the papers. The principal of MBC Institute of Technology and Engineering, upon verification, found the plaintiff to be present on the dates of examination and therefore forwarded an application of the plaintiff in this regard to the defendant number 5. Subsequently, defendant number 5 assured the plaintiff that the mark sheet would be rectified, and for that purpose, in good faith, the plaintiff handed over original mark sheet to the defendant number 5. In between January 1981 and May 1984, the plaintiff ran from pillar to post, making several approaches to defendant numbers 1 to 6, but was continued to be given false assurances. On 15th May 1984, the defendant number 5 threatened the plaintiff and directed him to appear at the examination afresh. It is claimed that the plaintiff answered both the papers quite satisfactorily, but was wrongly shown absent in those examinations, and thereby great injustice was perpetrated on him. The plaintiff, against the arbitrary, whimsical and illegal acts of the defendants, filed a petition before the Honorable High Court, Calcutta, being number such and such, in which the Honorable Court was pleased to observe that the state authorities violated the constitutional mandate of Article 21 in respect of the plaintiff. His chance to set up a career in technical field was taken away by the arbitrary action, and therefore cost of rupees 1,50,000 was awarded to the plaintiff. Against the said order, the state authorities preferred appeal before the division bench of Honorable High Court, Calcutta, which affirmed the order passed by the Honorable Single Bench, and further cost of rupees 1 lakh was imposed on the said authorities. The prayer for compensation was left to be decided by the appropriate court of law, and for that purpose, leave was granted to the plaintiff. It is contended that had the plaintiff passed the examination in 1980, he could have got service in Railways, Coal India Limited, BSNL, or such other organization in befitting rank, carrying monthly salary as per relevant rank, which was subject to upward revision time to time. Therefore, it is calculated that the plaintiff should get a compensation to the tune of such and such from the defendant number 1 to 6, for which he prayed for a decree of compensation. He further prayed for a decree of re-employment till the expected date of retirement, that is 16 January 1950. Usual prayers for cost and other reliefs were also incorporated in the plaint. Entering appearance, the defendant number 1 to 6 contested the suit by filing written statement, in which major contentions made in the plaint were denied as well as repudiated. Beyond stating that the suit was not maintainable, it was contended that the plaintiff appeared in the examination conducted by defendant number 1 in the year 1975 and failed in all theoretical papers. Said fact was suppressed by the plaintiff.
No specific objection as to section 82.
My lord, that is the
No issues framed.
no issues are also framed. Said fact was suppressed by the plaintiff in his plaint. The answer scripts of the plaintiff of his, and even so, my lord, there was a scope for amended written statement was also filed. In some cases, your lordship knows we missed. And as and when at the
Here,
time,
amended written statement was filed.
written statement was also then, and that point of time also this plea was not taken.
And the issues could have been recast also.
My lord. And issues, my lord, the learned judge himself, my lord, could have
Recast, yes, right.
the learned judge have failed, and only on the judgment taking into point that section 80. But I must say, arguments were in courts of arguments, even in courts of evidence also these points were not taken. In courts of argument, this point was taken for the first time, and that has been considered by the learned judge in the trial court below.
No, even if an issue is not framed, it has to be addressed, I mean, by the parties. But it appears from the judgment, we have had a cursory glance of the judgment also, you are not, rather, there is no advancement of argument from your end on section 80. Apparently shows that you are taken by surprise.
My lord, that is the thing. That is also I am just going to submit, because we were also not prepared. Section 80, mandatory provision, there are certain exceptions, or your lordship knows 80 subsection when section 80
Leave
for the
maybe,
timing
yes.
Can be, my lord, taken over. But that points has not been taken up. I just come back tomorrow and with the judgment. because-
Tomorrow we are sitting singly Friday.
That's the next day of.
Yes. Well, hard in part for further hearing on February 5, 2025. Very short matter. So
Very short
you come ready with the judgments, Mr. Shamol, and we'll consider those judgments and maybe.
My lord, it may be on 6th, 5th I have seen. It was 6th.
If you are short of matters.
My lord,
Very well. February 6, 2025.
at least, my lord, after so many days, we are doing some fast.
Really, some of the first step is the papers have become brittle, Mr. Shamol. We are feeling so sad.
After so many years, at least we are doing some first appeal.
We are talking, I mean, we are feeling so sad that people are languishing for so many years. Our fault.
Grateful.
Thank you.